You're welcome back. Let me quickly get to my take. The constitutional reform, the window is closing, and the only opportunity is now. First of all, I'd like to begin the take with a salute to civic courage. The Citizens' Platform on Constitutional Reform has risen to the occasion. In their June 12, 2026 press statement, a formidable steering committee anchored by CDD Ghana, Star Ghana, Foundation, Democracy Hub, Media Foundation for West Africa, Imani Africa, and the TUC, as well as the GJA, has sounded the alarm. This coalition, representing more than 90 civil society organizations, is performing the sacred watchdog duty that keeps democracy alive. They have looked at the state of our republic and declared with clarity and urgency, the window for constitutional reform is closing fast, and executive inertia is no longer tolerable. Here's their core concern: the narrowing window. The facts are plain. On January 26, 2026, the Constitution Review Committee, chaired by Professor H. Kwesi Prempeh, submitted its full report to the President. After exhaustive nationwide consultations, 4 months later, government announced a special cabinet meeting to finalize its position. That meeting, as we understand, is ongoing now. Media reports even hinted at amendment bills such as the long-awaited election of metropolitan, municipal, and district chief executives. But here is the glaring omission. Where is the roadmap? As the coalition rightly insists, a credible implementation plan detailing mechanisms, sequencing timelines, and institutional responsibilities is absent. And constitutional amendments are no child's play. Bills must be gazetted for 6 months before Parliament sees them. Entrenched provisions demand Council of State review and a national referendum. With the electoral calendar looming, delay means death to this project once again. Remember that we have spent millions of dollars on a similar project. We did it in Atamil's time. We did it in Akufo-Addo's time as well. And here we are, the very final opportunity with a parliament that is prime to get this done. Once in a lifetime. If we do not act now, reform will be swallowed by partisan electioneering. What we seek from the President, Mr. President, the call is clear. The executive must do the following things. 1, lay out a roadmap with strict timelines and milestones. 2, publish the CRC report immediately for the sovereign people to read. I mean the full report, not the initial one, which was not the full report. It was only about the recommendations. Clarify the implementation mechanisms, its mandate, composition, and inauguration. Communicate official positions on the CRC recommendations and subject them to genuine public engagement. You know that this is an eternal legacy. This is not another policy file gathering dust. Pursuing constitutional overhaul to completion will strengthen governance, insulate institutions from hyper-partisanship, and fortify our anti-corruption architecture. Champion this now, and it will stand as the enduring historic legacy of your presidency, Mr. President. There's a partisan threat we cannot overlook. Why the time is now. Let us be brutally honest. The only opportunity is now. If reform drifts into the election cycle, Ghana's toxic partisanship will devour it. Parties will weaponize amendment bills for electoral gain, not national interest. Once the nation fractures into tribal partisan camps, consensus becomes impossible. Remember what happened to the first CRC report. Miss this narrow window and the momentum dies. Mr. President, you know it. A genuine constitutional reset may never happen in our lifetime. Yes, we have a parliament that's just right for this to be done. The call to citizens, that's my call. This is not the burden of politicians or civil society, not mine. To every Ghanaian citizen, media house, faith-based organizations, traditional authority, worker and youth groups, the platform calls on us to remain vigilant and demanding. The Constitution is not the property of the Jubilee House or Parliament. It belongs to the people. Its renewal must be completed in our name and within our sight. Let us join this coalition in demanding a roadmap. The window is shutting, the clock is ticking, and the time to act is now. And that is my take. I'll be right back. You're welcome back, and we begin with Wontumi's 30 million Exim-Bank case. Should the Attorney General accept a plea deal? That's the questioning. As you know, Bernard Entwibuesiako, Chairman Wontumi, and his associates are facing 4 charges of defrauding by false pretense, altering forged documents, money laundering, and causing financial loss to the state. The prosecutors allege that they fraudulently obtained 14.3 million Ghana cedis in loans from the Ghana Exim-Bank, causing losses exceeding 30 million Ghana cedis. On the 5th of June, his lawyers formally requested a plea deal. That's what we call plea bargain with the Attorney General's office, who have also confirmed to the courts that that's what has happened. The question we are asking, should the Attorney General accept restitution, so to speak, in law through the plea deal, or insist on full trial and custodial punishment to deter elite fraud? Is a negotiated settlement justice served or justice compromised? Those are the questions we seek to answer for you this morning in our very first topic. My guest joining us via Zoom is Dr. Arthur Kobina-Kennedy, who is physician and political activist. Here in the studio, Dr. James Kwabena-Bomfe is here. He's CEO of Census and he's a lecturer at the UPSA. We also have Dr. Justice Yankson. That's a medical doctor, like Dr. Arthur Kennedy. He is also a lawyer and former General Secretary of the Ghana Medical Association. Nana J. Bafwewa, MP Mensha South and member Constitutional and Legal Affairs Committee and Vice Chairman Subsidiary Legislation, as well as Bernard Bediako Beidu, MP Akwetia, member Works and Housing Committees, will join us shortly. So let me begin by going straight to the Zoom. Dr. Arthur Kennedy, thank you very much. We haven't had you on this show in a long while. Please unmute your mic. All right.
Hello, can you hear me now?
Fantastic, fantastic.
Yes.
Right, so
yes.
How have you been?
I have been well, and I've been following you as usual. I think that your take was very good. I noticed that you focus overly on the presidency, even though Parliament has a very central role to play in constitutional reforms. I join your call, but I think that maybe sometimes our Parliament is too reactive, that maybe it can take more of a leadership role. But from my reading of constitutional history and reforms elsewhere, particularly in the United States, maybe reforms are better than piecemeal. And our problem is that we keep trying, in effect, to take the whole elephant in one bite instead of piecemeal. Right. But I join your call enthusiastically.
Thank you very much. The civil society platform that is pursuing this, led by the CDD and their partners, about 90 of them together. Let's hope that they're able to push it and we get this constitutional review done now, because from where I sit, if we don't get it done now, we never might get it done, at least not in our lifetime. We've done first, we've done second, all of them have been botched so far. And because of the architecture of the parliament, this particular parliament looks fit. And President Mahama, this will be, like I said, like an eternal legacy for you if you are able to do it. But time is running out on you if you don't start the process now. So, Dr. Kennedy, it's raining. I drove through the rains to here, this place. I've seen rubbish gathering all over the place. There's rainwater almost all over the place. And some of our guests are actually late. I'm sure they will tell you that they face this problem. I'm not too old. At 50, I'm seeing this over and again. I have moderated discussions over this over and again. I'm just tired of it.
And you should be. I think that we don't solve problems. I actually saw a video a week or so ago of the president as opposition leader talking about Omukoji loans. So and he said that when they come, they would return that function to local government and do this and do that. And that hasn't been done. It is an eternal testament to the failure of our democratic governance that we seem unable to solve something that is so fundamental and foundation. And that is unfortunate.
Yes, some preliminary comments. My other guests who are here, Nana Bafo also is ready now. So, I don't know. I was beaten a bit by the rain. I don't know. Doc, Bonfe.
I came through the rain.
And you saw that there's water gathering almost everywhere.
Yes, already.
Flood. I mean, it's flooding everywhere.
That is just one of it. And not just that. A gang of people or a group of young people who are mourning their dead, causing a blockade on the Ring Road Central, close to Nima Police Station, as if it is nobody's business. The indiscipline is just too much. We are not committed to building a nation, Samson. And that is, the greatest tragedy of this nation. When at independence, Osadifo said that we must realize that we are no longer a colonial, but a free and independent people. We must change our minds, our attitudes. This is our nation. No one will build it for us, but us. Are we committed to that? My young life, I don't see it. We do one step forward, two steps backwards. Yes, I am a perpetual optimist, but daily, I am increasingly getting worried that citizens and leaders alike, we aren't showing leadership. We must wake up.
Even after it killed over 150 people in 2015
we don't care.
And damaged, maimed several others, hundreds of them. Nana, I mean, young guys like you are taking over the leadership mantle. Is there hope for us? Look, when I was coming, I'm seeing rubbish is gathering everywhere. The rain is pushing them. So people take their rubbish. Some of them deliberately keep them. They wait for the rain because it's raining, and then they throw them out.
Okay. So thank you very much, Samson. There will be hope for us the moment our educated class come to realize that education is just to let them serve their country better and not to be worshipped. That is our bane as a country. You see, when you look at post-colonial countries, post-independent countries, they decided to pursue education as a means or as a tool for development. And so when you read countries like Singapore, when you study countries like Singapore, education was just a tool to change their circumstance. Ours, education hasn't been a tool to change our circumstance. Education has just been a way by which people then become lords in this country. Also, he's a medical doctor. Hey! Then he also comes very bossy. He doesn't feel accountable to even his patients. He's a lawyer, very bossy. He doesn't feel accountable to his clients. He's a teacher. Oh, teachers, they are somewhere. You understand? And then even in the family, the moment the doctor comes, hey, maybe doctor no na abano. Then everybody will prepare him special meal. He's the boss. He doesn't feel the need to even change the circumstance of his family. And so education has not been a tool to change our country. It has been a tool for people who have obtained it to be lords in this country. Take a place. I'll give you just, okay, you want to move on?
No, these are just your preliminary comment because you came in the rain and then we'll go to our main subject.
Go to a place like England, right? When you get to England, when you say you are looking for lawyers, you know that they are based at the Chancery Lane. When you come to Ghana, right, when you say our first lawyers, our first generation of lawyers, they are based in Adabraka.
That's right.
Go and look at Chancery Lane. Come and look at Adabraka. Go and look at our courthouses and go and look at the Crown Court. So, you see, you can tell. Go and look at our hospital.
For those who may not have an idea, what's the contrast you're making?
The contrast is that when we acquire education, even where we live and practice, it doesn't change. Whereas in those countries, when they acquire education, it really impacts the people.
Anyway, so he's talking about London, and I've been reading around, Nchibwe Siakon has written this piece, and he's lived in parts of the UK, and he's making a comparison, asking very basic questions, that where he lived, as it's raining and there's something, or any time the rubbish is being made, is being collected, you don't see it, right? We said what every house with a bin. Zoomlion led that, and they distributed it 100 million bins or so in homes, and yet people were still doing these things. I don't know if that project is continuing. Well, they were supposed to be, I'm reading that people are talking about the fact that the rubbish we're also seeing, part of it, because it's increasing, could be because the work that the people were doing, sweeping, all of it has been stopped. What do you think?
No, Samson, to be honest with you, some of us are beginning to lose faith in this country as far as our developmental trajectory is concerned. As Dr. Bonface said, we take one step forward and the next moment we take two back. We've never been truly committed to any activity that will improve our lot.
Right.
It is all about the politics and how much rent-seeking people at the end of the day will benefit from. Let's be honest with ourselves. We have been engulfed by filth all these years, and there are no meaningful approaches to solving them. As far back as the early times of our nationhood, when we gained independence, not long after Dr. Kwame Nkrumah's death, the Israelis came to Ghana wanting to construct proper drainage systems that will more or less deal with some of these issues. Ever since they stopped that project, practically we have not done anything. We sit back, we allow indiscipline and impunity to be the order of the day. Agencies of state that are supposed to enforce some of the bylaws are not working. You go to places that are supposed to be water reservoirs, as in the areas where when we have very high rains, the waters naturally will drift towards for our common good. We've allowed that to be filled by individuals, foreigners, all kinds of bits. if you ask today that what is our true sanitation arrangement in this country, I tell you what, we don't have any.
Oh, we have sanitation plans. So
look,
our sanitation plan was just Zoom Lion.
No,
without Zoom Lion, no
if you have
sanitation
something
plan.
Say on the shelves, and you are not implementing, say, what are you doing? These Aboboya boys, when you talk to them, they have no proper points that they dispose this refuse.
Do you realize that most of us now depend on them?
Yes, and when they pick it, they end up turning the rubbish around us. They turn around, dump them somewhere, and we are back to square one. Where are, in quote, proper landfill sites or incinerating points?
Okay.
Waste management, waste can be turned into energy. And we are all seeing the effect. Just as you said, on our way here, just about 30 minutes or less of rain. It was not even too heavy.
Yeah.
And the roads have turned into ponds.
Right.
You know, so...
Less than, actually not 30 minutes, 20 minutes. Yes. I left home when we were just about starting.
Exactly.
And I didn't move anywhere, then the whole place is flooded.
Yeah.
Okay. All right, all the dredging...
Something quickly, if we do not seriously consider decapitalizing Accra or decoupling the political capital from the commercial capital, all housed in one city which is overburdened. There's something we can do about it.
There's now this some
too many people living.
There's now this some Volta ecological zone. We start one thing, we don't do anything, we abandon it, go and start another one.
The GHS 2021 report said that you have got only 4 regions housing 54.6% of the population living there.
But you see, Dr. Beyond that, let me just add this. Beyond that, see, there are cities on this planet called Earth that have bigger populations than Accra. And they are still able to manage all these basic social services.
All right.
It is just the lack of commitment and direction on our part.
Right, right. So let me go to Dr. Arthur Kennedy and let's begin. But we pray the government, because this is government's job, we pay you to make sure that you keep our cities clean. It's becoming so dirty. Nobody is sweeping around. What's going on? All right? If you have a problem, and many people have problems with companies who have done some of these things, if you have a problem with Zoom Lion, for example, sit down and see how you can work it out, correct things. But when you completely, don't continue things, don't do things, and then suddenly we are dirty all over the place, it's not right. As we understand, they are moving into how many? Is it 29 countries so far? They have the muscle. Find out. Make sure they are doing the right thing. That's all we are demanding from the government. Otherwise, this is so bad. All right, so Dr. Arthur Kennedy, Wontumi, he's going to the Attorney General to beg to be, allowed some space, so to speak, so that perhaps he doesn't go to jail. And then he pays 30 million back to the state. And normally it comes with what we call reparation or restitution. Some interest will be put on it and so on. Some say the Attorney General should not accept it. He should just go through the trial and let him go to jail and rot in there. What do you say?
I'll come back to that in a moment, but it was interesting to hear the comments that people made about the rains and sanitation. The truth of the matter is that this is a failure of governance and it's even not partisan. Remember when Addo was going to make Accra the cleanest city in Africa? Nothing happened. And I was very sad, and I even wrote an op-ed on it when President Mahama declared a sanitation month, and then he gave some volunteers equipment. Sanitation is not something to be solved by volunteers. And with respect to Dr. Bonfe, regardless of whether you move the capital from Accra or not, you still have to clean what remains of Accra. Because it is the commercial capital doesn't mean you won't clean it. So at the end of the day, it's not changing the capital or anything. We need to have sanitation plans that deal with garbage, from collection to incineration or to landfill, and laws that are enforced so people don't litter. So now let me get to Chairman Wontumi.
Right.
I think that those who say the Attorney General shouldn't, in effect, engage are wrong. There can always be negotiations and a plea deal, but I think that punishment is an important part of these things. It should not lead to a situation where people just return the money and go scot-free. A nation that jails foul thieves and cassava thieves should not let big people go free when they commit crimes. So yes, the negotiation can save us prosecution cost and defense attorney cost and all that kind of thing. But still, punishment ought to be part of a plea deal. Here, a plea deal in the United States, for example, means that if this might have led to imprisonment for life, it may lead to, say, 10, 15 years of imprisonment. In other words, you might get a lesser sentence when you do a plea deal, but it does not mean that if you clearly committed a crime, you can walk away scot-free. So one should not presume anybody guilty. He's innocent until proven guilty. He should be able to engage. But I think that some kind of custodial sentence or criminal penalties must be on the table. I noticed that his lawyer is trying to withdraw from the case, and the Attorney General is trying to...
No, that's not the case in focus. That case is over. The Samra boy matter, that one is over. They are waiting for judgment. This one is the Export-Imports Bank, the loan he took for agricultural purposes. Yeah.
Okay, so I would just say that the government ought to engage, but custodial sentences and criminal punitive fines must be on the table. However, politics looms large in the background, because when you think of a situation where the government itself announced earlier that it is up to the discretion of the Attorney General to accept some of these plea deals, where people win cases in court and they thank the Asante and the president instead of thanking the judiciary, and where we randomly find nolle prosequis with lack of accountability about why they were filed and people got freed, the public has reason to be concerned about whether our legal system is tiered, one for the powerful or one for the weak. I think that we should be guided by the kind of retribution faced by cassava and foul thieves, and that big people ought not to get away just because they are big and connected people.
If the cassava and foul thieves don't want to negotiate plea deals, why should that be visited on somebody who wants to, exercise their rights in that regard?
Samson, the right to legal representation, you work to my admiration among people in our prisons, some of who were remanded just years ago, and their case have not been held. The reason their cases haven't been held is that sometimes they don't have lawyers, and if they have lawyers, these are volunteer lawyers who don't have time. So our justice system obviously depends on your ability to hire counsel. I'm just saying that we need to be careful that in the end, when one looks, if even innocently, we will not seem to be operating a system where if you are powerful and connected enough, you can loot the state and then dribble and get away with it. And the ultimate example is that when government changes, if Wontumi or any of these other people about whom we are making noises regards to Ura and others, if, God forbid, 2028, we find out that the NPP is in power, most of their problems will go away, regardless of whether they are guilty or not.
Did you say, God forbid, if NPP is in power, God forbid?
Yeah, God forbid on the legal front, because we know that's what is going to happen, because it happened to the NDC people.
Okay. So your statement was not that NPP should not return to power.
Well, that is a whole new show. The NPP, as it is framed now, as it is constituted now, unrepentant as it is, does not deserve to return to power. But that's a different show.
Okay. So Yes, Dr. Bonfe.
Well, just to Senior Atta Kennedy, I think that the issue of suggesting that the political capital be taken out is not to be seen as though I said that is the sole solution. It is one of them. In discipline regarding to development planning and thinking, you have got to look at...
Oh, you're going back there. That's
I'm not going
not
back
the
there.
subject for our discussion.
I just make the point that it is not a trivial matter, as he sought to make it look. You cannot have the number of people that you have within the space of Accra that you have. It beats every development thinking and planning model.
Thank you.
You see, this Wontumi matter, I want to raise a preliminary observation about our criminal justice system that is worrying. Samson, if you look at Article 19, it is unambiguous that the tenor of the language is that a person is deemed innocent until proven guilty. Indeed, the Constitution imposes on the state to afford and accord the individual accused every opportunity to self-defense.
It says facilities.
Exactly. To facilitate. And in fact, I have marked 19(2)(d) and E, that the person must be held in a language that he or she understands. My persons with disability are disadvantaged when it comes to this, but that is another matter for another day. Yet, it is almost as if once a report is made about somebody, the person is deemed guilty and must prove him or herself innocent. That is perversion. Justice turned upside down. And it is seen through the line of thinking from the investigation stage through, arraigning the person before court, and even the language in court that is sometimes used by judges, some judges. It is worrisome.
Before the arraignment, we do press conferences.
Thank you. And this flies in the face of Article 19. I just want to make that point. Samson, second, this Wontumi matter is not a Wontumi matter. And I don't know why we are making it Wontumi matter. What you read indicates that this is a loan acquired by a company that he heads.
Yes. There are 3 accused persons. I've asked my producers to put the charge sheet on. You see the charge sheet. There are 3 accused persons.
So why are we personalizing it?
Bernard Enchibu-Esiako, alias Wontumi, yes. Thomas Enchibu-Esiako at large. That means he can't be found. And then the 3rd accused person is Wontumi Farms Limited.
So it's a company.
Right.
Obviously, I'm sure it's a company limited by guarantee.
Well, it could be just...
Or a sole enterprise.
Yes.
Whatever it is. But we need to know. But if even this charge sheet is anything to go by, Samson, then we are not talking about Wontumi matter here. It is Wontumi and others.
Yes.
So we need to move away from personalizing it to his person. Now, is it the case that they went for a loan and have failed to meet the requirements of the payment of the loan?
That's number one. Documentations that were used to secure the loan
have been found
forged,
fraudulent. Now, the alleged is not been proven, right? The persons who approved of this facility, where are they? They are not part of the prosecution. Is there something called the relation of duty and negligence within our criminal justice system?
The prosecutorial discretion is that they want to go after these people.
That's an issue. Fairness.
Right.
The discretion you exercise as a prosecutor must be fair.
So
must be seen to be just.
Correct.
And I'm raising the issue that if you are prosecuting for an offense and there is a team of people who are associated or linked to that offense, why do you leave some and go ahead with others? That is another issue to raise. That said, now the loan arrangement and this plea bargain thing, could it even have been dealt with at the prosecution stage or by the prosecutors even before investigators? Because I understand the OSP in many of the convictions that, their success stories about 7 of them or so were plea bargains. And we need to make a distinction between a plea bargain that is based on a commitment, someone committing an offense and actually admitting to it and say that, okay, I've done this, blah, blah, blah. And then somebody going to secure a loan using fraudulent means or whatever, allegedly. And so that is there. For me, we have the plea bargain as part of our criminal justice system. What was the purpose for it? The purpose, I am sure, is enshrined in the Act that rather than go through full trial and sometimes end up wasting time and not getting what is due the state and people making away with whatever they are accused of, if there's a way we can recover something in the, for the use of the state. And then the issue of punishment is not thrown out. If the people are supposed to go through some punishment, they go through. So the question you are posing, should the AG accept? I think the discretion, again, will be at the AGs.
The AG is working for all of us.
They must consider all the issues at hand. How did we get here? And why are we looking at only these people and not the entire stream of people that so far have shown this issue should have covered? And once it is fair in the interest of the state that the AG accepts the plea bargain and deal with it just in a just manner, why not? If not, and they must go through full trial, I think that can also be.
Okay, so Samson, before I proceed, Dr. Atta Kennedy wanted to say something to him. All political parties, major political parties, once in their lifetime,
and as you can see, Bernard, BBB is here, and I think he's
already in Ghana.
He's the one who is properly represented.
Thank you.
All of us, we are not. All right.
So, major political parties, once in their lifetime, or sometimes in their lifetime, do go through different phases. We do acknowledge that our party, something is wrong. But he also would acknowledge that it is in the light of that we went to Congress, made constitutional changes, and we are restructuring it, we are reorganizing it. NDC has had that phase before. We are also going through that phase before. If you go to most advanced countries, their major political parties do go through these phases. We believe that the Lord who sees our heart and mind would see that we are sincere towards that and will definitely give us the opportunity one day and will not forbid us from coming to power in 2028. We know that he's a true MPP member. He should join us. We know, for instance, that Dr. Mahmoud Bawumia, our flag bearer, has been engaging him. And so, in the light of that, sometimes we pray that they should be quite reserved in such comments, particularly when somebody has shown good faith towards...
But tough love is good, so why not?
It's not in public sometimes, especially when you are having discussions in private.
Okay.
And you're a party member.
All right. Should the AG accept a plea bargain?
We need to appreciate this. When you are a prosecutor, you have choices to make. And when you are a defense counsel, you also have choices to make. I can imagine that the defense team or Dr. Chairman Wontumi taking cognizance of the enormity of cases that they are having to deal with. At the
3 cases so far.
3 cases so far. May decide that let's take advantage of this option. After all, it's a loan. A loan is meant to be paid. And so if anybody is raising issues in the manner in which the loan was procured, and you are eventually going to pay it, and there's the option to pursue plea bargain, why don't you explore it? That doesn't mean there is guilt. Because even when you look at our plea bargain law, the Criminal Offences Procedure and Other Offences Amendment Act, right? It stipulates that in the process, the prosecutor would have to make known to you the fact that, you are not guilty, particularly where you have not pleaded guilty, and the fact that you have a right to a fair trial, And so all those...
It doesn't stop there. It says the prosecutor must make available to you all evidence that they have that will go to exculpate you.
Exactly.
So you must see it in full to make the decision whether you still want to do a plea bargain.
Exactly. So full disclosure. Now, the point is that we need to emphasize within context that the decision to do plea bargaining is not an admission of guilt. That ought to be emphasized. We also have to emphasize that the decision will be based on choices that you, as a lawyer and your client, may want to make, given the circumstances. And if you are in the shoes of Chairman Wontumi, when you are already dealing with 3 prosecutions, and you know that, yes, there's no dispute that I took a loan, and a loan is a loan. A loan is not the stealing of money. A loan is the procurement of financial assistance or credit, which is meant to be paid in accordance with the terms and conditions of it. And you know that you will eventually pay it. And somebody is saying that because of that, you are going to be prosecuted. And there's the option of entering into an agreement whereby you will return the money. I would always advise my client, given the circumstance, that look, this is a low-hanging fruit. Let's take advantage of it. And then let's move to deal with the 3 other ones that are already pending in court. We need to bear in mind
There'll be two others left.
There will be 2 others left.
Yes.
And so that, in my view, is very strategic as a lawyer from where I sit. Indeed, if I'm also acting as the Attorney General, right, it will be consistent with the Attorney General's approach so far. Because if you look at the way and manner he dealt with the Dr. Addo case, he said that he was prioritizing asset recovery and avoid prolonged costly litigation. And so this initiation, if
that's the case, he accepted 60%.
That was the case he assessed.
And then filed a nolli prosequi to terminate the case.
Prosequi, in respect of the Dr. Addo matter.
Right.
And so that would, if the Attorney General proceeds to engage Chairman Wontumi, right, that would also be consistent with his approach so far. And so, with the greatest of respect, I think that let's all acknowledge that this is not an admission of guilt. And I like what my brother Dr. Bonfe said, that look, oftentimes we are in a hurry to crucify people in this country. I think we need to pull the brakes on it and then look at things from their proper perspective, right? Plea bargain exists for some of these reasons. You and I know that from the plea bargain law, one of the things that the Attorney General may decide to do will be to even withdraw the charges. The Attorney General may even decide to go for a lesser charge. And the Attorney General may even decide that, look, I will not even prosecute at all. The Attorney General may equally also decide that, look, instead of a bigger sentence or a harsher sentence, let's negotiate for something lesser. So, in my humble view, this is something that we should not be in a hurry to make conclusions that, big men are getting away and so on and so forth.
But you know that the public suspicion is that once somebody says they want to do a plea deal, it is to suggest that they have seen the end at the beginning.
That is why.
And they want to avoid jail.
That is why there should be transparency in the manner which it is done. That is why there should be full disclosure. And for me, that is why some of these discussions are also necessary, like I highlighted. And so it is very necessary that we have some of these discussions.
Dr. Anyenini, if it's just a loan, so to speak, I suppose maybe you may have paid part of the loan, but here you have the entire loan amount you are going to have to pay 30 million or so, and then, in a plea deal, you are likely to be asked to pay extra. In fact, if it's a loan, interest would have been accruing, and so all of this will be taken into account, unless it was an interest-free loan. Why would the person not rather want to pursue the case and just pay his loan rather than do a plea deal, which may require them to plead guilty, and then they will have the ex-convict, label on them.
Well, Samson, I think that we need to quickly distinguish two things. One, taking a loan from a bank is a purely civil matter. It is not a criminal matter.
Commercial transaction.
Yes. Under those circumstances, nobody will take you to a criminal court for any criminal processes. If anything at all, whoever lends the money to you has to take you on a civil way. However, in this Wontumi case, if you listen to what the AG is saying, the processes leading to the acquisition of that loan had some criminal elements. They are talking about forgery, defrauding by false pretenses, and what have you. So I think we need to make that distinction clear, that it is not just a question of you took a loan and go and pay. You are now being tackled on the criminal front, not necessarily the civil one. Now, for me, I think this is a very simple matter. Chairman Wontumi and the others, they have every right per our law to trigger the provisions for a plea bargaining arrangement. The law is enshrined in our Criminal and Other Offences Procedure Amendment Act 2022, Act 1079. It makes it clear that any person charged, so whether you are charged for, let's say, stealing 2 pieces of kenke, 2 balls of kenke, whether it's plantain or a goat or whatever, that plea bargaining arrangement is available to you. The only time the law makes exceptions are things within the realm of treason, high treason, rape, defilement, and others.
That's
so
right.
all the bits that come outside of the exceptions, every individual in this country who is charged is entitled. Now, the law also makes it clear that when you are charged, anytime before judgment is delivered, you have the right to go into this plea bargaining.
So those who cannot go into that arrangement, they are, if you are charged with treason or high treason, high crime, rape, defilement, genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking, and an offense related to public elections.
Yes. So outside of that exceptions that the law has created, anybody can trigger it. And I will want, as lawyers, to start using that, especially for people who have committed petty crimes and sometimes their families are ready to pay and what have you. We bundle them, we put them in Saom and other places, we can't even feed them and all of it. The other bit about this whole process that I think we need to handle properly and also educate, the general population, and I think a lot will also rest on the AG and his team, is that there should be fairness, transparency, and people should understand what is happening. For example, the law makes it clear what you can do. Offenses can be substituted in bigger offenses, so to speak. Smaller ones can take the place of that. So a big offense, so to speak, you get a smaller offense. The punishments, you can work around it to make sure that instead of going in for a longer period, you have a lesser punishment. And then the payment of whatever you may have taken. That is the area I'm very concerned about. You see, we need to make sure that all the 3 categories as listed in the law, 162A, sections 1 and 2, put together, become the basis for all that we do. Because if you just take the money and you don't punish the person to any extent, it is as if, as we say, for people in political authority, they can just go scot-free and, they pay something, they are free. But if you look at the law carefully, using a purposive approach to interpret it, you pay restitution, and for me, that restitution should be commensurate with whatever you took plus more, i.e. interest and what have you. Because you cannot go and take, say, 30 million, benefit from it, and go back and pay 30 million. If you even decide to put the 30 million in nothing like, you don't do much, you just put it in even tables, you are going to make money out of it. That will become a window for people to just make money of us, and then they don't pay any restitution to anybody. So instances like we had with the Do4 case where somebody had to pay 60%, I think it was a wrong. Because the person has already benefited, and even the amount to pay, you say pay 60%. We've made losses. If the restitution is such that you are paying the full plus more, then I am happy with it. If you have to go to jail for, say, 10 months, or 1 year, or 2 years, and they say you go for 2 weeks, it is still punishment.
Which was not actually a loan anyway.
Okay.
Notice I'm saying that whatever the arrangements are, it is not even about the loans, but my point is that when you go into the plea bargaining, the 162A.
So what you are seeing, what you are seeing, and for our viewers, as we tell you on Newsfile, here we bring clarity to controversies. We give you the best of education you can get. So this is the plea bargaining law, and these are the things that Dr. Justice Jansen is speaking to. If you get into the plea bargain, this is potentially what may happen. It says a person charged with a criminal offense may at any time before judgment, negotiate with the Attorney General for a plea agreement. So the plea agreement, they will have discussions. Once they agree, they will make it into, call it a proper agreement. They will both sign. You bring this, you bring that, you do this, you may become a witness for us, or you will do this, or you give us ABC. Then, if you do that, it says they will either A, reduce an offense charge or a lesser offense. They can reduce the offenses you have in charge. If the offense is, say, something that will get you into jail for, say, 40 years, they can bring it to something that's a lesser offense. They can bring it to something that gets you into jail for 3 years. Reduce, maybe, Sedina, we are getting to her shortly. She had 78 charges. They can bring it down to less than 78 charges, because you can agree on some of the things for which you should not stand trial anymore. And then B, they can withdraw a charge against the accused person. That place you are free forever. No ex-convict tag is with you. To reduce the punishment for an offense charged within the law that prescribes the punishment. So you can also get a lesser punishment when you do a plea deal. All right. Yes.
Yeah, so once you do Section 1, as we've seen, then 2, the agreement proper, which now has to be sent to court. People should, know that the court can actually reject the deal within the 30-day period that the court allows you to do that when it's properly placed before it. However, you can even still go back and do another plea arrangement even after the court has rejected what the AG or the parties have put before the court. So I think that there's a certain judicial supervision as well that comes in whilst we are doing these processes. And I think if we go back and do things properly, a lot of the problems or the perceptions as we are seeing now may actually be watered down. We know that it is there for everybody. We know that whether you are a politician, whether you are an ordinary citizen like you and I, we can all go into those arrangements as and when we find ourselves in those unfortunate situations.
All right. Yes, Bernard. Should the AG accept it or it shouldn't? Some of your party people are insisting that he should not accept it at all. This is oral. We want to jail the people.
I was just going to conclude that. For me, once the law makes this available to all of us, it shouldn't be that we should encourage the AG to start saying that I will accept or not accept. It is the details of the case.
That matters.
That matters. And that is what will merit whether certain things will have to be agreed on in the negotiations or otherwise.
Okay. Yes, Bernard.
Good morning.
Morning.
Good morning to
But we must place on record that this Attorney General has said at the very onset that if you want a plea deal, he wants you to bring it to the attention of the court. So there will not be any discussion just between the two of you. But, the courts don't discuss the plea deals.
Of the law.
Yeah, the courts don't discuss the plea deals. It's just a notice to the court. Right.
That's true. So good morning to my big brothers here. our viewers and listeners. And sorry for being late. We all know what is happening, the rains and all that.
You were forgiven before you asked.
Thank you, big brother.
Especially because you are in this house.
Yes, which you filled. So, here we are. You see, Samson, it is because of, for me, it's because of submissions with the greatest respect, such as that of my big brother, Honorable, that some of our party members are going the way they are going. You see, before I even come to the plea bargain, it is important, I was listening, but I'm not too sure if you've actually stated what is before the court to your viewers and listeners. It's important they know. I have the brief facts, what was filed by the Attorney General. At least, let me read two for your viewers and listeners to know what has happened. Paragraph 2. Sometime in January 2018.
Paragraph 1 is very short, so
okay, so let me do one.
Yeah.
It's because I don't want us to go the route of
that's
last
okay.
day. Thank you. So 1, the first accused person, A1, and A1 here is Chairman Wontumi, a 50-year-old entrepreneur, is a native of Kuntunase in the Ashanti region. He's the sole shareholder. Kuntanase.
Kuntase, yes.
Thank you. In the Ashanti region, he is the sole shareholder and one of the 2 directors of the third accused person. That's A3, that's the company.
Wontumi Limited.
Yes. The second accused person, A2, we are told A2 is at large. I don't know whether he's in now. He's run away, he's gone. The second accused person, A2, is the other director of A3, which is the company, whose subject is general farming, agriculture, business, and processing, was incorporated and authorized to commence business on December 14, 2017, and this date is very important. 2, sometime in January 2018, A1 approached Ghana Export-Import Bank, the bank, for a grant of 19 million Ghana cedi. Now, Dr. Bonfe, please note it. A1 approach. A1 is Chairman Wontumi.
Yes.
He approached the Exim-Bank for a grant of 19 million Ghana cedi.
For his person or
Hold
his
on.
company?
I'm reading.
Yes, go ahead.
Relax.
I'm interested.
Cedi facility to embark on a farming venture. In the application letter, A1 ostensibly as A3's managing director declared that a parcel of land, 100,000 acres in size, has been secured for the project. Accompanying the grant application letter are 2 documents. The first is a letter titled Board Resolution Letter and dated January 23, 2018. The letter was signed by A2, who described himself as the board chairman of A3. The letter stated that the grant application was authorized by A3's board of directors through a resolution passed on December 9th, 2017. Please take note of this date. According to the letter, the resolution happened on December 9th, 2017. We are told by the fact that the company was incorporated on December 14th, 2017. So if you submitted a letter to the bank with...
Check the date of incorporation again.
The date of incorporation is December 14th, 2017.
Look at it properly. Is that it? December 2017.
2017.
Okay, earlier you had read 2019.
I'm
right, okay, thank you.
Okay, so it is December 14th, 2017, the date of incorporation. And he submitted a letter, a purported resolution of the board dated December 9, 2017.
Before the company was born.
Before the company was born. What could be more fraudulent than this? If it's true that these...
Exactly.
No, hold on. These are the facts.
So if it is true...
You see,
continue. Just
allow
go.
me. So the documents, as the state is alleging to have perused, indicates that the company was formed on December 14, 2017, whilst a document purported to be in the name of a non-existent company was on December 9, 2017.
And the prosecutors will be so incompetent to give us wrong dates on all of these things. So let's presume that the documents are what they are.
Yes. So to even proceed, you see, so I agree partially with Dr. Bonfe when he says that other persons must answer some questions. Because these were submitted to the bank, who are supposed to have people who at least should do some due diligence. But let's fast forward. I am saying that, you see, if these are the facts, as has been presented by the state, then I would respectfully submit that, yes, a plea bargain is part of our laws. But in the agreement, I would respectfully, very respectfully submit that he should be made to either admit to some of these things, so that this issue of a plea bargain doesn't necessarily mean the person is guilty will not be there. If he refuses to do that, and I'll read some sections of the law. If he refuses to do that, let's go through the trial. Let's go through the trial, so that it's not made to appear as though, because this is, as Doc said, this is not a matter of demanding what has been taken from the bank.
Right.
It would have been a civil matter. But we are saying that you use fraud to secure the loan. That is what is before the court. It's not about how much has been taken and the fact that you have refused to pay. The reason we are in court, no, but you use fraud in securing the loan, which the state is so much determined to prove in court. But if you say that the state should not have that opportunity to prove in court, and you want to curtail the process and perhaps go by the agreement you have with the state, and let's also put it this way, it is not necessarily the case that every plea bargain would result in payment of money. Some, you know this.
Sometimes, so, maybe.
Sometimes. It's not always. Maybe we've even read here that it may even lead to maybe the reduction or the proffering a lesser, what do you call it? Punishment, and even lesser charge and all that.
Sometimes the person is actually offering to become a witness, or is offering to show you the other criminals, so to speak. That you may not get, but for that person.
Absolutely. So a lot happens. So we are saying that every Ghanaian would want to, honestly, unless he admits to this, that yes, and I'm sure in the agreements or in negotiating, a lot of these things will play out. If he refuses to admit that, yes, I did these things, I would respectfully submit that the AG should not go for it. Let us have this proving court, so that some of these comments will not come up. That, oh, he paid the money not because he's guilty. Because it is a matter of crime. We are not talking about the money he took and may not have paid back. We are saying that he used fraud, and that is what is before the court. So it is for the state to prove that indeed he used fraud. And that is, if you read the count one, it's the count one of...
You made that point, yes.
But you see, Bernard,
yeah,
you should also pay attention. Count 3.
Yes.
Go to count 3.
Money laundering.
Yes.
Yeah.
So that is after you have taken the loan.
Yeah.
What you did with the money.
Because I don't have time, but the brief facts also tell us what he did with the money. Withdrawing from the third accused, the company, and using it for himself, putting some money elsewhere. It's all here, but because of time. You see, Sam, this is how far we have come as a people. Now, if you look at even the plea bargain, and we've said this, in fact, it is not automatic that even the AG agrees with whatever you are coming with. And the final decision rests even with the court. And if you read 162H, the court can even, if 168 of Act 1079, that is the Plea Bargain Act, popularly called the Criminal and Other Offences Procedure Amendment Act 2022, 162H, and with your permission, if I may read one. The court shall not accept a plea agreement unless the court is satisfied that A, the accused is of sound mind, B, the accused person entered into and signed the plea agreement voluntarily, C, there is a factual basis for the plea agreement. If the court is of the opinion that there is no factual basis for the plea agreement, the court, regardless of the agreement, the court may shoot it down. So it is not a fait accompli. It's not as if once you come up, I'll pay the money, and then that ends it. A lot would have to go into it. There are procedures. And so I am of the view that
you should read 162H2.
162H2. Where the court accepts the plea, the court shall call on the yes, that's even important. Shall call on the accused person to plead to a charge in the plea agreement. So even 3, where the accused person pleads guilty to the charge, the court shall record the plea and convict the person, the accused person. So there will be a conviction. But you see, even with 4, if you don't plead guilty, the court shall treat the plea as withdrawn from the plea agreement and make order for the trial to proceed. So it's a long haul. And I am saying that to begin with, the AG in negotiating with him, if there should be any negotiation, should first test the sentiments of the people of Ghana in respect of this case, at least to be sure.
What's the sentiments of the people?
Of course, people, and you've said it. Look, if he's not guilty, don't go into any plea negotiation with him. If he says he's not guilty, that's my humble opinion.
Okay.
If he's no, of course, because the law affords the citizen the opportunity to trigger this. No, see, that's what I said earlier, that you shouldn't go into the realm where we suddenly will make the Attorney General so powerful that he decides whether the law has to be. No, the law. Listen, it says
the thing is that unless the Attorney General withdraws the charge, yes, you must plead guilty. Otherwise, there's no plea.
Exactly.
Yes. But that's the law.
Yes. But
and the law has the law has made provision for you to appear before the court. Respectfully, the judge, like I said earlier, there's some judicial supervision in there as well. The judge will want to make sure that, generally speaking, the right things are being done. So that's why I'm saying that we shouldn't let it look as if the AG is so powerful that now, because of somebody, you don't have to give them the
Let me come here quickly.
But you know that in practice, the judges will often defer to the Attorney General on these plea matters. Yes.
But it's when the details are presented before the judge.
To say that if you are not guilty, you not plead, you not enter into plea negotiations is clearly not accurate.
Exactly.
And to the extent that you want to say that because the judge will invite you to plead guilty, that is the basis for that conclusion, is also not accurate. Otherwise, the law would not say that one of the things that Attorney General may agree to is to withdraw the charge. And so if a charge is withdrawn, there will be nothing to plead guilty to.
Yeah, but it could be that you are actually guilty. You have admitted your guilt before the Attorney General withdraws something.
And you may also not be guilty.
Allow me.
That's not what I'm saying at all.
We need to approach this, right? When you are reading an act, you read it as a whole. To the extent that a charge should be withdrawn, right? Or a charge is withdrawn, there will be nothing for you to plead guilty to.
No, I'm talking about the AG asking you to admit to it when you are having the discussion.
No, but I'm saying that it is one of the things the AG may do.
Right.
You see, we need to understand something.
Because when the charge is withdrawn, there's nothing to plead to.
Exactly. There's something we need to appreciate. This whole plea deal thing, arrangement, is grounded on the Constitution in terms of a person's right to fair trial. And the AG's obligation, prosecutorial obligation. In other words, the two of them sit to negotiate that I have a right to fair trial. You have a right to prosecute. We are both dispensing with it so that we can have an arrangement. That is the philosophy behind it.
Thank you. Kabila, sorry.
There's a point. There's a point.
You spoke for a long time.
You spoke for a long time.
You still speak.
Yes.
Don't get back. I'll get
there's
back.
A point. Samson.
Wait, no, Doc, you don't come in again.
You say that.
Wait, Samson, you are not done. You are coming.
You say that to read the charges out and make it seem like gospel. Very respectful, we are all lawyers. In recent times, we've seen the AG come to hold press conferences. For instance, the Dubois trial. We've seen things come out that are different from what the AG. We've seen, for instance, the Gift-Owari trial. Yeah. We've seen the record of proceedings, and we have witnessed some of the things the AG made us believe in the press conferences. are different from exactly what is transpiring in court. And so to say that what the AG has put down by way of a charge and brief facts is gospel, very respectfully, flies in the face of Article 19, clause 2C.
All right.
Right?
Thank you.
You have a right.
Thank you. Yes, Dr. Bonfe. Yeah.
I just wanted to make the 2 points. One, that sometimes pre-incorporation contracts could be recognized and enforced. I said sometimes. You can disagree with me, but there are many instances where pre-incorporation contracts are enforced depending on how they are. So how did this matter start? And I'm curious about it based on the tangent that my brother has taken. Is it that Exim-Bank, from whom the facility was taken, had issues and reported? And in pursuance of what they had reported, these things were uncovered?
If the bank does not report,
hold on.
How does Yoko come in?
I'm just raising the issue. How then are persons from the bank who supervised this whole arrangement that my brother is copiously telling us,
that's a question you have raised already.
Yes.
But when you said pre-incorporation contracts, what do you mean? Do you mean that there can be a board resolution even before the company is incorporated?
No, that's not what I'm saying.
But this is what we are talking about. Okay.
These are
allegations that he is put out here.
It's not he. It's not him.
Okay.
It's what is before the courts, which is led to somebody asking that, can we get out of the courtroom a bit because I want to see you.
I think that this whole discussion, I began by saying that there is good reason why our criminal justice system introduced this plea bargain. If it is available in our system and we can pursue it, let's pursue it righteously.
Thank you. No, let him finish. He has to finish. He has to finish.
No, just a quick one, I beg you. See, Samson, I think we also need to let people understand one thing. The AG's role is not just one of prosecution, but to serve justice.
That's right.
Thank you.
That is very key.
All right, thank you.
And that is why
Bernard.
the process is,
Bernard,
he has to do everything.
Thank you. That's a good point.
We should understand that the plea bargaining act would normally called, so the Criminal and Other Procedure Amendment Act is
2022.
2022 is ostensibly inserted in our Criminal Procedure Act after 162.
That's right.
That's correct. So 162 talks about conviction and charges pending. So it is after the 162 that this is supposed to kick in ordinarily. But you see, and you understand what I'm saying, without saying much, you see, I never said that the chairman Wontumi or the accused should come and plead necessarily after whatever arrangement has been made or negotiation. That's not what I said. I am saying that, in my candid opinion, personally, I think that if the AG is to accept anything of this nature and not proceed, there must be some concession. There must be an admission of guilt at the negotiation stage. I'm not talking about the court.
But the negotiation is always a give and take.
Yes, lawyers, but you see, no, and that is why, if you agree, then I will not proceed to, prosecute the matter, which will land you in jail.
The law's requirement. The law's requirement.
Is that what was done?
Gentlemen, sorry. The law's requirement that, Bernard, the law's requirement that the Attorney General should make full disclosure.
Yes.
You, the accused person, the Attorney General should give you all the documents that he's going to use in court. What is he supposed to do? He's supposed to help you to know what you concede or not concede.
Absolutely. But you see, and that is why I'm saying that, you see, some of these commentaries that even when or if there is supposed to be this arrangement or negotiation, it doesn't mean he's guilty. At the end of the day, I know the spin that will be put on this. So the AG, of course, he's also a politician. Let's not also, he's a lawyer like us. He's a politician as well. And all this will play out. So I'm sure he's mindful. And that is why, that was in 2025 when he said what you just said, that if you have anything, alert the court. Of course, the detail will not be discussed in court, but alert the court. Don't come to my office. Because of the political consequence.
And here, the lawyer for Wontumi, his company, wrote to him on the 5th of June.
Yes.
And then he decided to bring it to the attention of the court.
Absolutely.
In compliance with the law.
No,
Right.
that's exactly what it is. So what I'm saying essentially is this. The state is alleging that this has happened.
Imagine that he says, I'm not going to admit any guilt before the Attorney General, and I'm not going to the court to do any of that, but the money you are seeking, here it is. You want interest, here is the interest. No, I'm asking a question. Here is the interest. Take it, withdraw the charge, I'm not proceeding. It's take it or leave it. If you don't, we'll continue the prosecution.
Yes.
You say the prosecution should continue.
I personally believe
but you know
so,
the prosecution can end without the state getting a dime. You
of course, that means it's not.
The prosecution too may continue, and your government may change, another government may come, and there may be an only prosecutor filed in. And then
editorial choices.
Perspective.
Do you remember the ambulance, the Akufo-Addo and Japa ambulance
allow me.
case?
Maybe it may help.
Do you remember that case?
Yeah, I do.
Do you know that they proposed to pay the money? 2.3 million?
We ended up
billion, is it? No. Million
USD.
It's not USD. It's
at that time.
no, USD. And we didn't take advantage. Do you see how the case ended?
Let me
The prosecution got zero.
Prosecutorial choices.
Please, let me help. Anybody who owes any entity, if it is about owing, you know this would not be the process. It's a clearly civil matter. So if they've taken money and they've not paid for it, the state can initiate processes to take the money, you know this, through civil action. So that one, it's not in doubt. But as you said, Doc, why we are in court is not because they owe the bank. And that point has to be made forcefully.
So you scoop for it
please.
Target.
No, you see, who is targeting who? The point the matter in court is a matter of crime. Where the court or the state is saying that you use fraudulent means to procure the loan. If it is not true, let him go scot-free. If he's not paid what he took from the bank, there are other processes other than this to take the money. So for me, it's neither here nor there. If he is not, and I would be first to say that if he's not guilty of this, let nobody take any money away from him. Let's not put the two together
The other processes to take the money. Bernard, the other processes to take the money.
Which money?
Which is civil, right?
Yes.
You know civil doesn't lead to jail.
But nobody is saying he should at all costs be in jail.
Okay.
So if it is the money we want, it is not this action. Sam, that's the point I'm making. If he's taking money and he's not paid, this is not the action to take the money. Let's emphasize this. Samson. That will be a civil matter. But in this case, we are saying he committed a crime. So it is for the state to prove the crime. If the state is not able to prove it, let him go scot-free. That doesn't mean we can still not take the money through a civil action. Samson, let me say this.
Let me see if Dr. Kennedy, having listened to all of you, has a small point to make before we take a break and come to the next issue of Sedina Tamaklo-Atieno. Yes, Dr. Kennedy.
Yes, a couple of small points.
Sorry. Let me make this correction first. I was referring to the ambulance case. It was 2.4 million euros, not dollars. 2.4 million euros. Okay, yes, go on.
Nana J. Bafuewua made some interesting points, buttressed by others. And somebody even said sometimes we are too much in a hurry to crucify people. Let me give you the view from the streets. Sometimes we are way too slow to crucify people. I think that the wheels of justice grind too slowly. And I still insist, if you go do a survey, most people think there is one kind of justice for powerful, connected people and another one for lay people. Maybe if Chairman Wontumi wasn't the NPP regional chairman and a powerful figure in government, the bank would not have been as willing and accommodating as they turned out to be. So let us make sure that justice serves all people equally. Nana J. Bafo referred to my comment on the NPP.
But Doc, but should we also not educate the ordinary person, so to speak, the poor man, that plea bargaining is also there for them as well? I've done plea bargaining for people who are not wealthy, who are not rich, and who found themselves in difficult situations. Actually, the plea bargain was, a spread payment, an amortization. They paid it over a period of time. But at the time, it was before 2022. Until 2022, the 1993 law, or is it 94 law? 93 law does not allow you to do a plea bargain and go free. You must always plead guilty.
So the plea bargain exists for all.
That's right.
Just like all of us have a right to justice and representation and blah, blah, blah. I'm just saying that the plea bargain is not as accessible to the poor in practice as it is to the rich and powerful and connected. That's the point I'm making.
Doc, in the United States, Doc, in the United States, plea bargain accounts for over 90% of the convictions in the United States. In some cases, 98% of the convictions in the United States are based on plea bargains.
Yes, and a lot of poor people complain about it because part of why the poor do plea bargain is that they are not able to afford vigorous legal representation. So they end up pleading in plea bargains to things that if they could afford rigorous legal representation, they will not plead to. So all what I'm saying is that in practice, just as in the US, and I thank you for bringing that up, in Ghana too, the powerful and more resource are able to have access to better terms when they do plea bargains. Yeah. Our purpose should be able to equalize justice so that the rich and poor alike will have equal access to all branches of justice and all facets of it. That's what I'm saying. I'm also saying that the idea that sometimes we are too eager to convict people is respectfully bull. I mean, we saw all these NDC people like Dr. Pune and Kwabena Dufo and others dribbled the legal system for years, and as soon as their government came, they were cutting deals for them left and right. That is not justice. It's a perverted justice. And not only that, let me take on Honorable Ajay Bafo, who made a comment on my comment on the MPP. I met Dr. Bawumia one-on-one for 45 minutes. They made the meeting public. I thought it was confidential. But I'll tell you one of the things, and when I left, I chose to keep quiet. And I'm an optimistic person, so I still hold out hope that we'll get to where we need to get to. I'll tell you a small part of the meeting. I told him that the day before meeting him, I told my mother-in-law, who is a diehard MPP supporter, that I was going to meet Dr. Bawumia. The woman said, Doctor, yesim mo munu wanna debaye, so wanna debaye dia we adia pa bonabaso. Then he added, and so yasi wa mrentim krofu diskapra untuminka. I repeated that to the good doctor. He said nothing, no defense. I went on to tell him about the activities of people like Abronya and others and gave him chapter and verse, giving him a chance to defend himself. He said nothing. So respectfully, don't provoke me. There are a lot of things, but I think it was a confidential meeting, so let's leave it here.
All right.
And that's the reason why I haven't gone.
Thank you, Dr. Kennedy. So we take a quick break and we return to ask. And some of my panelists have already asked me the question, is Sedina in jail? She was a fugitive from justice, and she got convicted. She asked for, permission to go treat herself while her trial was ongoing. She was going to court anyway. And then one day she said, my situation is bad. Judge, can you please allow me go take care of myself in the US and return? And judge said, okay, we seize your passport, but here it is. On medical grounds. Of course, the judge, Ehunumobro, gave her her passport. She went to the US, never came back, and the trial ended. She was convicted in 2024. She filed an appeal against her conviction. It was only in February this year that the appeal became ripe. She filed her arguments insisting that the absential trial, the fact that she did not participate in the trial to the end, she was not heard, is wrong. The Court of Appeal should say that that is wrong, and that the 10 years is just too much. So that too, something should be done about it. But now a new argument comes up. According to our law, you begin your sentence from the day it is pronounced. Some are saying, since it was pronounced in 2024, she has served 2 years and 2 months already. Some say, no, that is absurd. She has to start all over. What is going to happen? My guest, James Kwabena Bonfe Jr., Bernard Bediako Beidu, Arthur Kobna Kennedy, Justice Samson, Nana J. Bafoewa. We'll be right back. Right, from 30 million Ghana cedis plea bargain, where many people think that is not a punishment, but of course there is punishment in it because you may go to jail. In fact, you in most cases, in plea bargains, you plead guilty and there will be the ex-convict tag on you for your life. When we are talking about 30 million, now let's talk about 90 million Ghana cedis. Will she serve the 10 years in jail? Is she in jail in the first place? So, as you know, she faced 78 charges with her deputy, Daniel Exim, and was convicted in absentia in 2024 for stealing, money laundering, and causing financial loss in the amount that I mentioned, 90 million Ghana cedis. She was sentenced to 10 years imprisonment, but she remained in the United States as a fugitive. She has now been extradited to Ghana. We are told that she came in wheelchair. She has an appeal that has been pending since she was convicted. And that appeal challenges, among others, the fairness of the trial in absentia and the proportionality of the 10 years. She says it is disproportionate. So, let's find out. Will she serve all the 10 years, or she has already served 2 years and 2 months, as some people are claiming? And will she go to the court and ask for bail pending appeal? Will she be granted? Or in the end, if she loses on all of that, on health grounds, she may get a pardon, presidential pardon. On this one, who should I start with? Dr. Yankson.
Okay, so, Samson, you know, we've been talking about Sedina having been tried in absentia. And I wonder whether it is truly the case. Because, you see, when the trial started, at all times she was in this jurisdiction, she was in courts up to a point. And then she decided on her own volition to go out of this country with the permission of the courts. She refused to come back. So her own act of omission or commission was what resulted in a situation where at the time that the judgment was being pronounced, she was not in court that day. So personally, I even doubt if that amounts to a trial in absentia. Because generally, for trials in absentia, the person never goes through. Generally speaking, you never see the person in the jurisdiction or even in the court.
I guess it is with an understanding that people understand she's not available yet. The trial has gone. Just like the Benjilo case, you know, in this country, those are the only situations we talk trial in absentia. But they are, because those are popular. I know similar situations. In fact, when Sedina's trial was going on, before the same judge, another person also ran away, could not be found. And then that person too, the trial ended. He was convicted. I don't know if he's back. If he's back, he'll go and start his trial, his sentence.
So, I mean, let me just conclude on this. When the trial was ongoing and she was in this jurisdiction, she had counsel in court as well.
That's right.
So the court had actually seen you. The court had seen your counsel. All documentations have been put in place. The trial was ongoing. The court gives you permission to go and sort your medical bits out and come back. You never wrote back to the court to tell them that because maybe your doctors or your situation has deteriorated, you are forced to probably stay more than you were supposed to stay, for which reason the court probably should look at your circumstances, what have you. You decided not to come back. Now, I think that the judicial processes, both in Ghana and the US, especially with the extradition bits, have actually been fair to Sedina. Because one, in Ghana, you had the opportunity to defend yourself, and you decided at a point that you, in quote, ran away. When we triggered the extradition process...
That part is on appeal. So let's not talk about it, whether it is fair or not. She says...
No, what I'm saying that...
She says continuing the trial in her absence is unfair, and so the Court of Appeal should...
I agree. What I'm saying that, thus far, I think that she had the opportunity and things went right. With the extradition bit, just as the law on extradition, requires, and then our bilateral treaty with the US also requires, she went through the processes in the Nevada District Court, and then it was determined that she has to be extradited.
She's surrounded.
What I'm saying that she went through the court processes in the District Court of Nevada. That is not about the surrendering.
Okay.
The process is what I'm talking about.
Okay.
And then finally, the court took the decision that she has to be brought to Ghana. The various diplomatic and executive arrangements were put in place because this extradition process is one that is judicial, but with a lot of executive, influence and arrangement determination in there as well. So she's been brought here, and as it stands now, as far as I'm concerned, she should be in custody by now. You posed an earlier question that when our court pronounced you as having been convicted, there's a school of thought now that is saying that from that day you start serving your sentence. I think under a purposive interpretation, it will be absurd if you are nowhere to be found. Because usually, the pronouncement will go with you being physically taken from the courtroom whilst you are present, straight to jail. The prison officers will do the basic things, the registry will do what they will have to do, and then you are taken in and you start serving. So for me, the bit about currently she served part of a judge, the sentencing and all that, I think it shouldn't arise.
Section 315
yes.
of your Criminal and Other Procedure Act says that a sentence commences the day it is pronounced.
I agree, but that's
why they are saying, if that is what it is, if that's what the law is, then the day it was pronounced, it started.
That would be just a literal reading or interpretation. That's why I said, under a purposive approach, the MOPA approach, you cannot tell me that you make a pronouncement, you have not been put into custody, you are free somewhere, partying, enjoying, or whatever it is. And then after a certain number of years or weeks or months, depending on how long you were sentenced, it is deemed that you served your sentence. Serving a sentence includes the physical restraints in the prison. And there are rules around it. So for me, as far as I'm concerned, the sentencing hasn't started. I also respect her decision to appeal to the next level, i.e. the appeal court, because it is part of our criminal jurisdiction or our legal system. As to whether the appeal court will agree with her or not is another matter. But for now, I think the sentencing should start. The question is, where is she at this moment? I think the authorities should let us know.
They have told us that when she got to the tarmac and she was wheeled out, she was handed to the police and prison authorities.
Yeah, so they should be able to tell us where she is. Look, even if at this point, let's say...
She has been convicted to serve and sentenced to jail.
Yes.
And she's been handed to police and prison authorities. why are you saying we should be told anything again?
You raised that, where is she? Because you see, this is, in quote, a high profile.
Should we be asking that question?
I think it is just that for transparency's sake, we should be made to know some of these.
When people are put in prison, do they show us videos that he's in fact in prison?
No, that is not what I'm saying. People have been sent to prison, and we know that as of this, this particular person is at his home. The prison service can even decide to transfer you from his home to Akuse. But at least we know. Having a loop from our justice system, you being extradited back to Ghana, having been convicted before you got into Ghana, I think that we should let the system work. If, for example, or assuming without admitting that she even has a health problem, the prison service has a health directorate. They can decide to take care of you in there or bring you to, say, a hospital. But at that point, they know that they brought you from the prison to, say, a hospital. And I think it is fair. It will dampen a bit of the, the tension around, or let's say, the uncertainties as to whether high-profile cases will be treated the same as, in quotes, the ordinary man or otherwise. I think it is just fair. They should let us know. I mean, the AG has taken a position that even before prosecution, sometimes he can do press conferences. So it's all about information giving. And if we ought to know, I think it is just fair. But the criminal justice system should be allowed to take its course. For me, that's the simple thing.
All right. Yes, Dr. Wanfe.
Well, I think my brother asks a very important question. Where is she?
Why? Why should we be asking that question?
It's important. We just discussed an issue and we talked about the need for transparency, especially when it involves public person and even ordinary citizens without any public exposure. It's important that we are transparent, that we are fair and just to everybody, regardless of status or position in society. So it's important.
So
remember,
we are allowed to think that when she was handed to the police and prisons people, they took her to Holiday Inn or the Palms.
No, so she's in prison custody currently as we speak.
They gave her to the people who should take her there.
No, so I want from you, and you know for a fact that when they took custody of her, they took her to the prison that she was supposed, because I want to grant.
That's the presumption.
I want to grant that she started serving the sentence the day judgment was delivered. So she's done some 2 years and
2 months.
And 2 months.
But who says a sentence free? Walking freely or
no. He's not saying.
I'm saying.
He's not saying.
Granted that.
Okay.
That sentence, that part of the sentence is she has served it, even whilst away. Granted. The moment she landed here, she should continue. And if she was continuing, where were we expecting her to have served the 2 years and 2 months that has already elapsed? That for me is a fundamental question. So where is she? Now you ask the question about her appeal. Samson, was she fair? If the state, she is posing the question that the state was unfair to her, that the trial continued to judgment when she left with an excuse and abused that permission.
Didn't report back, didn't bring any information. The judge bent back, kept delayed,
so was she
kept asking,
fair,
is she coming, is she not?
Was she fair to the state, to the court, and to the prosecution when she did that?
She even put Alex Mold in trouble because he stood shorty for him, and his property was at stake.
Yes.
So really, that argument will not rise at all. She did not conduct herself well with that. But
just to add, the court even issued a warrant for her arrest.
Yes, at the end of it.
Yes.
So really, for me, if she's appealing, she has the right to appeal. She should appeal and stop this argument about trial continuance was unfair to her. But that said, Samson, the question is, I want to go back to the genesis of things sometimes, because we get a lot of information from there. Sedina was standing trial for, or she stood trial and was convicted for 93 million Ghana cedis, whatever that was used for, where is the money? Has the state made an attempt to recover the money beyond the sentencing? Or it is just the sentencing that we are, satisfied with, and that whatever happened to the money, she serves the 10-year sentence and end of matter. I would want to know what the state is doing about it.
Maybe we should have done a plea bargain. And collected some of the money.
I'm raising an issue with respect to our criminal justice system when it involves embezzlements or financial losses such as this, where we want to concentrate on, if you like, what my brother Bernard was focusing on, the deterrent aspect and not the restitution aspect, where I said you appear to.
I'll address it.
You see, so we need to look at that. So that it's not as if I get the opportunity or I abuse a certain opportunity to go and amass money at the expense of the state, I serve a sentence and I can come back to enjoy it. I don't think that should be the case. The last point I want to make about this is that we did not need to get here. Samson, what were our state investigative bodies doing throughout that period and only waited to act when the government that Sedina was serving in had left office before they triggered it?
No. The extradition
I'm not
was triggered.
No.
Yeah.
Talking about her prosecution.
Okay.
It did not start on
the extradition
the
request.
regime.
So let me state this. The extradition request from Ghana was made in July of 2024.
Yes.
Under Godfrey Dame.
Yes.
She had filed the appeal on the 9th of May 2024.
Oh.
Yeah. She was, okay, once again, she was, as we know now, she was convicted.
You are talking about a different matter.
She was convicted on the 16th of April 2024. And then on the 9th of May, she filed an appeal. And then July 2024, the state triggered the extradition request. And then June 9, we got her back.
I'm talking about her trial. When the trial began, it didn't begin with the regime that she served under. And I'm saying that our investigative bodies should have started this thing when she was serving. Because the issues that we are talking about, that Godfrey Dame's team presented to court, related to when she was serving as head of MASLOC. And at that time, are we saying that we did not, as a state, see what was going on? I'm trying to preach against the idea that accountability is only possible or prosecution is only possible when the regime you served under is no more in government.
But you know that is what we do here, regime accountability.
But I'm saying we need to move away from that. That if there are things going on today that are untoward, that are wrong, we should face them. Than wait till a new regime comes and then it takes on the political color and we say all sorts of things. That said, I will conclude that this nation is ours to build. The way we are going about it with these kinds of issues, I don't think we are building.
Bernard, the judge waited for her for 16 good months to return so that she could have her turn. And she failed. And the judge went ahead with the process.
Yes. I'll deal with that.
So, thank you so much. You see, first and foremost, maybe this will help a correction of an impression that has been created, or maybe a factual inaccuracy in something you said. I have a copy of the 74-page
call it the address to the Supreme to the Court of Appeal,
yes.
Statement of case or written submissions.
Written submissions
of
the convict.
Yeah.
And
of Enoch Digbe, his lawyer.
Yes. Yeah.
On behalf of the convict.
And some, there is nowhere, and I think on page 33 and 34, even though I have the, I wanted to use this because maybe they filed further grounds. So I wanted to use that.
There's nowhere what?
There is nowhere that has ever been stated that they are appealing the decision on grounds of, how do you call it? She being tried in absentia.
Oh, there is.
Please help me.
They make the point. It's there. I've read it.
No, the grounds.
The grounds.
Yeah, the grounds. It's there.
Please help me.
It's there. You go on. I'll show you. It's there.
C, D, I have E, F, G,
If you look at the grounds,
yes.
the first ground is not there, Samson.
They talk about unfairness.
The conviction and sentence of the first accused, appellant, for the offenses of conspiracy to steal, stealing, conspiracy to cause financial loss to the state, causing financial loss to the state, causing loss to public property, improper payment of public funds, unauthorized commitment to resulting in financial obligation to government, money laundering and breach of the Procurement Act is unreasonable and cannot be supported having regard to the evidence on record. The court below erred in convicting the first accused for conspiracy to steal and stealing. The court below erred in convicting the first accused for conspiring to cause financial loss. So it's not there. It's not anywhere.
Okay, so what I have done, and I can show you, it's part of their argument about the fairness that in her absence, they are raising natural justice rules about it. And they actually say that the court knew her situation, that she was not well. You go on.
Yes, so I think I've read something like that, but I thought you were referring to the grounds.
Okay.
It's not the case. Sam, so I think that we should state, and the spokesperson for the government addressed Ghanaians even before I think the U.S. embassy put out whatever, and told us that yes, the woman has been brought in, and they have handed, they've taken her through the protocols at the airport and have handed her over to the enforcement officers, the law enforcement, as well as the prison service, and they are undergoing. That's how far the state can come. I mean, in terms of the government machinery. As we speak, she's in the hands of the prison service. If you doubt this, Samson can call the prison service, whether they have custody of her.
But is it too difficult for the state or the individuals within the state to be apprised of information?
Okay, so let's do this. Let's Bernard continue his presentation.
There is no ambiguity in what the spokesperson for the government said. They've given her to them. And you know, they have to take you are a lawyer, you know this. Some protocols, which even includes taking her through medical examination to find out whether she's not even taking seed, whether she's not even pregnant. You know, that's one
yes, I agree.
So, of course, but that will not be the spokesperson for the government who will not be there to supervise it. For him to come and tell you that we are undergoing this. What he has to do is to tell you how far the government or the state has come. Giving her to the prison service, they take her through the protocol. So if you have any doubt, you call the prison service. Do you have her? But it's not for the state to now. That's not how we run.
Bernard, when I raised my question, what I said is,
I've told you where she is.
No, you haven't said anything to us. Bernard, what I said was that the prison service has to tell us. And I even went on to mention that if it's about health-related issues, they even have a medical directorate and what have you.
So maybe Joy News journalists go and find out.
Yes,
and come and tell them.
Absolutely. So it's not with me or the government. Now, you see, yes, it's been said rightly. Look, President Mahama has said, and he has that record, we all know, of prosecuting his own. That must be made forthfully. It's never happened under the Fourth Republic. Under his tenure, his own appointee, Honorable Abu Gapeli, was prosecuted.
It happened under President Akufo-Addo. 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 It happened under President Akufo-Addo.
Who was prosecuted?
Malam.
He is not a member of his party. Was he a member of You said an appointee.
You want us to go into that?
No. You said
it's okay. It's appointee.
Don't run away from your word.
That's okay.
Appointee.
So, Honorable Abugapele was and has always been part of the closet of President Mahama, and yet was prosecuted. We will not, let me emphasize this, he will be the last to shield, and we understand the narrative and even the fact that the woman has been brought and people are asking her whereabouts when the prison service is there to ask.
The initial question is, you are chasing Oforiatta, where is Sedina?
We brought her.
And we have to ask the question, is legitimate?
Yeah. Why is the legitimacy here? Because the woman has been brought in.
Yeah.
She is with the people she is supposed to be with.
She was not brought in on your order.
It doesn't really matter.
It matters.
When we came to power, we didn't do anything to obstruct the process. It's very important to state that. The process had not ended. And there is nothing you can put on record to suggest that this government did anything to frustrate the process. We didn't. And she's been successfully brought in. And we have told the people of Ghana, we have given her to the prison service. Now, it's a fact also that they filed an appeal, which is within, and the appeal was not, let me also emphasize, that it is not the case that the appeal was filed after the change of government. The appeal was filed.
I've spoken about
yes,
that. It was
but
filed
let me
on
also,
the 9th of May.
On the
9th of May,
we are not here only to discuss what you has been discussed.
No, but Samson,
it is Newsfile.
Please understand. Understand him.
You brought that in when I raised the issue.
Let me say that you haven't said it. So let me.
So it is fair.
But let's also put on record that the appeal was filed immediately, not long after the conviction.
Right.
So.
Except that the appeal became ripe for hearing.
So I'll tell you what happened
in February.
Yes, because a lot happened. The Attorney General challenged even the appeal and said that because she was not in the jurisdiction, she didn't have the mandate or the legal right to appeal. That process went on before.
She can't instruct lawyers.
No, so I'm saying that these things happened in 2024.
Right.
A lot happened. It's not as if there was inertia, as if nothing happened at all. So let that matter also be emphasized. It is within her right. And we all admit that nobody can take that right away from her. She
must exercise it.
If you read the 74-page submissions, you understand what her issues are. It is not for me to say she's right or wrong. It is for the Court of Appeal, the three wise men, to decide her fate. In the meantime, she's been brought in as a state. We have to ensure that she serves her sentence. And that is exactly what we have done.
And from where you sit, the sentence starts now? Or?
Well, so you see, yes, you refer to 315. And the 315, yes, that's 3, yes. And with your permission, if I may read to you.
Go on.
A sentence of imprisonment commences on and includes the day on which it is pronounced. So strict interpretation, that is what it is. There is even a case, the Oyo versus the
sentence of imprisonment. How can imprisonment start when a person is free?
So, no, I agree with you. I agree with him.
The Oyo you are referring to.
Yes, no, that matter.
Justice Benning was right about what he said.
Yes.
That one, they had already said some 2 years or so before they got convicted. Yes. So they were saying that, are they to us? Yes. You know, and they said, no, we come back.
So I agree with you.
How much more are you working freely on it?
I agree with you. Technically, legally.
No, but Justice, they are saying that if the court said you can't backdate the judgment, then the one that has already spent some already outside, that is also, I didn't call for the answer.
Yes, I know. So Sam, yes, for me, I think that the prison, of course, should start from when she is taken in.
Okay.
That's what I think, and there is no dispute about that.
But she's entitled to mount a challenge on that question.
Absolutely, she can. She has all the rights. Look, regardless, no matter how you think a particular process of something filed in court is frivolous, it doesn't lie within. I mean, it's for the court to decide.
People's fears are that there's some, I don't know about that trajectory, that there's some trajectory that once you are someone within the government or the government supports you or the party supports you and you take a case, you can grant it that you will walk. So she may get a bail on pending the appeal, or she may win the appeal and get out, or if she loses all of that, she may get a presidential pardon.
I can tell you, what I've heard, I can tell you at least in the interim, I do not know of the fee, but President Mahama has never contemplated a pardon. Never, I can tell you on authority, has never contemplated a pardon. In fact, President Mahama has that record of not. You see, people refer to Muntie 3, and it's funny. Did Muntie 3, did anybody steal Ghana's money? You see, that matter is a different matter. So for you to refer to Muntie 3 as somebody, or if you want to compare apples
their reference is rather about recent things. They are not talking about...
I've heard that there's. Please, we are not just here. There is Newsfile. We summarize, they summarize whatever has been said within the week. So please, not necessarily you, but you've heard it. People have raised the issue of Muntie 3, and I don't know whether my senior would raise it. But you see, what I'm saying is this. If you want to compare apple with apple, it is about Honorable Abugapele and this one. He even appealed and all that, but he never got the pardon from President Mahama. At least it was on the grounds of ill health that President Akufo-Addo pardoned him. President Mahama believes that if you serve a public office, you must account for it one day. And that is exactly what we have. If her lawyers think that something untoward has happened, they should use the judicial process.
Right to
and at the end of the day,
we are told.
Yes, that's what we hear too.
That's more ill health than Abu
No, but that would not be determined at the airport. That would not be determined at the airport.
But there's a reason the public is being told that she was wheeled.
But the woman left Ghana unwell. And for the fact that the court granted her access to leave, we cannot debate that. She left unwell. Perhaps she is back unwell. And you can't take that away. So if she is unwell, she knows the processes to initiate to do what. But she even has some remedies available to her under the law, including what you just said, bail pending appeal. It is for the courts to decide eventually.
Do you think if she asks for bail, she will get? She should get it. As a lawyer, do you think she's entitled?
I know
to
the
bail?
grounds, but if the grounds,
do you think she's entitled?
But she would have already been granted bail. Her accomplice.
Her accomplice didn't run from.
No, but he has been granted bail.
But he didn't run.
So I want to put that on record.
Throughout the trial,
and he's been granted
got convicted,
appeal.
filed an appeal, and asked for bail. Yeah. That's a different thing.
That's a different thing. But he is not the first to be ever granted bail.
I ask your opinion as a lawyer.
So you see, my opinion, it depends on what the arguments would be. If she is able to produce documents, verified documents from wherever she was, to actually prove that throughout the time we were looking for her and we're not finding her, she was actually unwell, and these are verified. And indeed, because you cannot just be unwell at the time of the extradition. You understand? That would raise.
She was actually unwell.
She was unwell before she left.
She never told the court. She never.
That's a different.
Or she was in coma, perhaps.
It's possible.
And she had no family who would communicate.
It's for her to state that to the court. It's not for the state. And you see, when I sit here, I represent the state in terms of the government of the day. So I'm careful what I say. These are all for her to prove.
Typically, when somebody runs away, runs bail, jumps bail. Yes. Do they get bail again when they ask?
Typically, no.
Okay.
Because it's one of the requirements under 96.
So, prima facie, you don't expect that she
No,
get
I
bail?
don't. If there is something that she has to, if she has a superior proof to what we know, it is for her to put before the court.
The superior proof will be that she got into coma and she had no family, nobody to communicate.
So let's wait and see.
Okay.
But you see, what I trust our judiciary, and I know they will do justice to it. But let us also not put in the minds of anybody that should the judiciary grant her any request, it amounts to this whatever theory. Because the government is not interested in having her walk away for free.
All right.
It is the state against her. And for now, the state is ensuring that she serves her sentence. Whatever right she has under the law is for her lawyers to proceed with that.
Great.
The three wise men will determine it.
Yes, Nana, it's your turn.
So, a few housekeeping matters to start with. Being tried in absentia is not the same as not being represented or not participating in the trial. There are two different things.
Explain to us.
So when you are tried in absentia, it simply means that the trial took place in your absence. However, you may have had representation in the course of the trial. And so it is not to say that Sedina Tamaklo did not participate in her trial. In fact, when you look at the judgment, she participated through her lawyer, my very good friend, Agbesi Jakpasu. Indeed, Agbesi Jakpasu cross-examined the prosecution witness as lawyer for Sedina Tamaklo. And so she participated in the trial. She participated in the trial. In fact, the only thing she did not do was to have opened her defense. In other words, to have called witnesses to support her case.
And that is central.
But you forget that, firstly, you have a right to call your defense. If you choose not to, right, it does not make the trial defective. It doesn't.
There was actually a submission of no case before things proceeded.
And so she participated fully in the trial. Indeed, evidence in trial is not limited to the evidence of the prosecution. Cross-examination evidence, which is adduced by your lawyers, also amounts to evidence. And so she fully participated in the trial.
Oh, partially or fully?
No, if you say partially, it means that she was denied the right. She wasn't denied the right. There are choices. We as lawyers make choices. I've been in a matter where, look, I was representing an insurance company, a major insurance company, in an employment dispute. When the plaintiff was done with his case, I told the judge that I would not call a witness. And I didn't call a witness. That would not be the first time. These are choices you make as a lawyer in a matter. And so, if the lawyer did not withdraw, stayed, cross-examined for the prosecution to close his case, nothing stopped the lawyer from calling witnesses. The lawyer actually proceeded to file a submission of no case. And so the lawyer had every right to call witnesses. The lawyer chose not to call witnesses. So that was a choice the lawyer made. The woman fully participated in the matter. The woman fully participated. Let's not throw dust into the eyes of the public. As lawyers, we make choices. If lawyer Agbesi Jakpasu had chosen as lawyer for Sedina Tamaklo to withdraw as the lawyer, when Sedina left and the court decided to do trial in absentia, they would have said there was no participation. But the lawyer participated. And the lawyer chose not to call witnesses. So there was participation. It is on the basis of that the court went or proceeded to evaluate the evidence before it, and then deliver judgment. Her presence was necessary to the extent that at the point of judgment, right, or following it, immediately following it, she was supposed to have been handed over to the police and prison officers for her to be taken into custody. That is where the absentia or her absence became an issue. But it is not in respect of the trial. These are distinct matters and we need to put them on record. Now, let's proceed, my brother. We should also put on record that her judgment, her conviction and sentencing was in April 2024. By July 2024, the government of Nana Addo Dankwa Akufo-Addo, right, by the Attorney General of the time, Mr. Godfrey Adame, had initiated proceedings or processes to ensure that she was returned to Ghana by July 2024. So not long after the conviction, the government had taken these steps. It should also be put on record that proceedings had been ongoing from that period, but Sedina was fighting it, but only decided to return to the Republic of Ghana when the NDC government took office. So she surrendered. To the American authorities that she wanted to come back home. So the whole processes did not come to its lawful conclusion. She took the option of surrender. And so that should also be put on record.
Why do you think she would have done that?
Obviously, I'm coming. And you will see where I'm going to. My brother, we should also put on record that in this republic, no appointee of President Mahama has been convicted during his tenure. That is necessary because there is a distinction between prosecution and conviction. They are two distinct things. In fact, whilst the case of Mr. Abu-Gapele was ongoing, the trial of Mr. Afari Agbesi-Woyome was also ongoing. Whereas Agbesi-Woyome's trial was completed during the tenure of President Mahama, Mr. Abu-Gapele's was not completed. It came to an end during the tenure of Nana Addo Dankwa Akufo-Addo. When there was evidence of money taken by Mr. Agbesi-Woyome, we saw how the trial panned out, right? And so we have to put on record that no conviction has taken place. And there was the potential that Abu-Gapele's could have ended in the manner which Agbesi-Woyome's ended. I said there was the potential, and that's a potential. I'm saying there was a potential, and we have to put that on record. This record is very necessary because of recent happenings, and I'm happy you raised those issues. In recent times, we have seen a trend where the government has done everything to make sure that its appointees or members of the ruling party don't go through trial or don't go through prosecution, and for that matter, don't see conviction. We even saw that in the case of a gentleman who speaks for the government outside of the country. We saw that where the Supreme Court found a way to make him go not suffer the wrath of the court, the order of the court. We saw that. And so when people begin to be suspicious, it is not in a vacuum. It is on the basis of these facts that the people are suspicious. In fact, the people will be suspicious when we file a right to information request to the Attorney General to disclose to us the terms of his agreement with Dr. Dufo in that settlement arrangement. And the Attorney General refuses to make that disclosure. When the Attorney General is requested to appear before Parliament and make these disclosure, and even before the representatives of the people, they find a way not to make that disclosure. It raises suspicion about the transparency and credibility of the government in terms of the happenings of these matters. And so I'm not surprised that Ghanaians are suspicious that Madam Sedina Tamaklo is indeed not in prison custody. But I want to put it on record that the members of the Constitutional and Legal Affairs of Parliament, the NPP members on that committee, will be taking steps in the coming week to confirm, to verify that indeed she's in prison custody. Because if the government is not going to make that disclosure, we are going to ensure that the people of Ghana get to know. Because it cannot be business as usual, whereby when members of the ruling party commit one offense or the other, a separate justice system is applied to them. But when the ordinary Ghanaian commits an offense, he is treated like an ordinary person. There should be equality before the law, and that's very important. What are we talking about in terms of Sedina Tamaklo? When you read the judgment,
but serve them notice before you go, so that you don't meet what happened at the Afari hospital. We are going to come to that.
We'll serve them notice. We'll serve the necessary notice. Samson, Sedina Tamaklo. She was.
It's actually Sedina
Tamaklo.
Sharon.
She has been convicted and sentenced for stealing, whilst the chief executive of MASLOC. Do you know MASLOC, what they do? Small loans that are supposed to be given to our women in particular, the market women, to support them. Small loans, state money, which is supposed to be lent at very flexible terms and rates to these people. She was charged for stealing them. One instance of them, one of the charges, it had to do with money which she had lent, right? Which MASLOC was supposed to have lent to a savings and loans company called Batampa.
Yeah.
That money, they decided to return it because they were no longer interested in the loan arrangement. She, rather than having them pay the money into the company's
Even
account,
though she had paid by check.
even though she
And
had,
they also wanted to return in check.
then she said they should rather bring cash. And she arranged for them to meet her at Bachuna, Total. And when she met them,
Before you proceed, sorry. So she gives money to the Obatampa savings and loans, is it?
yep,
Then they have to now negotiate the interest. And the interest she wants, the company says is too high. We can't give you that.
yes,
I have paused to ask myself the question. So she gave the money out before they began to negotiate the interest.
exactly.
They didn't finish before she gave them the money.
That should,
Then they said that because what you are asking, we can't afford. Take your money back. And then she says, I don't want the check. Bring me cash. Okay, go on.
That should tell it. That should tell you. That should tell you what she had been doing there. Samson. She acknowledges receipt of the money. That evidence is tendered in court as Exhibit A. Prior to that evidence being tendered in court, at Yoko, she said that she recognizes the signature to be hers, except that she denies that she's the one that signed it. At the court, her lawyer cross-examined the board chairman or the representative of Obatampa. The representative of Obatampa actually came to court to testify. Her lawyer actually cross-examined the representative of Obatampa. The court actually found, on the basis of the evidence before it, that indeed she has stolen that money. Right? There were several of such evidence. We were allowed to talk. Why are you prompting him to let me stop?
You've done beyond. I don't well. You've done beyond.
Spoke for like 30 minutes.
I spoke for
Samson.
So I've been doing something very deliberate for you, but you are not paying attention. When you finish, play back the show, and you see how long you have been speaking. That's fine. Go on.
Thanks for acknowledging that.
What? You're almost done.
Samson. So the evidence before the court, Samson, was enormous. The court, stealing of an amount of 3.19 million cedis. Now, causing financial loss of 1.9 million cedis. Committing MASLOC into various transactions, procurement transactions, without board approval, without procurement authorization by the PPA. Right? Running to the tunes of millions of cedis. Right? His lawyer actually cross-examined
the money to the victims.
The money to the victims. Money supposed to be for the flood victims. Or no, fire victims. She kept all of them to herself.
No, by the record, she kept some, not all.
Samson. Money for sensitization, money for monitoring and evaluation.
And all of that, please, the record showed that some was done, not all. So let's say, don't say all of it.
And this is, you see, what we are discussing on this table, it's not an allegation.
It's a judgment.
It's a judgment.
Yeah.
And the evidence before the court has gone through the fire of cross-examination.
That's why it's under appeal.
It's under. I agree. But Samson, the point we have to acknowledge is that we must be careful. You see, we cannot compare Chairman Wontumi's case to this. And I want to make that point because of what I'm going to say.
Which of his case?
We said in Tamaklo's case.
Which of Wontumi's cases?
Whatever. We were the plea negotiations and all that.
The Exim case.
Yes.
We have to be careful. This is a case of a government appointee, an appointee of a government, taking advantage of an office to steal public money. We need to be careful because we must, particularly because of recent polls where the Ghanaian people are becoming despondent of politicians, and in some section they are calling for military rule and so on and so forth. We should be careful as appointees. There are times when, at this point, I'm making it to President Mahama. There are times when, like it happened in the Bible, there are times when we should allow people to be crucified just to save the face of politicians or the political class. We should not be seen to be doing anything to protect some of the people. Look, there is an unfortunate, for me, it may be a coincidence, but it raises red flag because of what I've done as a lawyer and a risk person and so on and so forth for these years. Then, Samson, not long after Sedina Tamaklu, so before Sedina Tamaklu, a few days before there will be the announcement that Sedina Tamaklu will be returning home. Then her main accomplice was granted bail by the court. Pending appeal. Was granted bail. Right? As though to prepare for events ahead. We have to be careful.
So you have done many cases where someone is in custody, you file an appeal, you ask for bail before the appeal is determined, and you get the bail.
Circumstances are different. Facts are different on a case-by-case basis. And when you have a circumstance of this nature, we have to be careful. That's all I'm saying, my brother. Now, what, in terms of MASLOC and the issues arising and all that, Samson, I want to end by saying that we need a lot more transparency from the Attorney General when it comes to when it's dealing with its own. That transparency is not forthcoming. You see, take somebody like Edubuahin's case. Take somebody like...
I need you to conclude. I'm going to...
Take Edubuahin's case, for instance. This is the Attorney General who decides to even withhold information. When, as Minister of Justice, you should be disclosing information.
Well, the court has compelled them to disclose it. Let's move on.
But the Attorney General withheld it first. Otherwise, the court wouldn't have compelled him. Now, when it comes to his own, he's dealing with them with a different standard.
How?
Samson, the knowledge prosecutors. Now, Sedina's accomplice. How it was approached. Go and find the ruling and read.
Sedina's accomplice. Is the Attorney General the Court of Appeal?
He was the Attorney General represented the state. The Attorney General represented the state. And did what? Samson, you mean to say that it doesn't take two to tango in litigation? Is that what you mean?
You haven't said anything.
Good.
The court granted him bail, not the Attorney General.
Be careful, Samson. The court will grant you bail based on representations from both sides. We should be careful not to be seen that when it comes to our own, the Attorney General has a different approach.
In this case, the Attorney General did not oppose the bail. Is that what you're saying?
Samson, I'm saying that we should be careful not to be seen that when it comes to why is it that in respect of Edubuahin, a crucial...
You are insinuating, you are not saying anything.
I'm saying that why is it that...
What did the Attorney General do wrong in the bail application of Daniel?
Did he oppose the application or not?
Wait. Samson, wait, let me ask you a question. First and foremost, haven't I given you a background?
You have.
The background from the very many knowledge prosecutors.
You have.
Haven't I? Haven't I referred to the case of a certain gentleman who a court ordered that he should be arrested on a warrant?
So the Supreme Court quashed that.
Good. At the Supreme Court, who was supposed to have represented the state?
Of course. The court.
Samson, let's move on.
That case was against...
I'm saying there is a trend.
That case was
Samson,
against the court.
I'm saying that there is a trend. That trend suggests an uneven...
You have still not said anything. You haven't said that the Attorney General did not oppose the bail for the former Deputy MASLOC boss operations. You haven't said so. And even if you have said so, you haven't shown us why that would be wrong.
I'm saying, because get the ruling.
There are cases in which the Attorney General has a standing order. He doesn't file opposition to bail in them.
Samson.
Right. All right. Thank you. I'm going to Dr. Arthur Kennedy. So for those of you just joining us, we are talking about Sedina Tamaklu's matter. She was convicted, conspiracy to steal 17 counts of that, willfully causing financial loss to the state 20 counts, stealing 15 counts, conspiracy to willfully cause financial loss, 12 counts, money laundering, 4 counts, causing loss to public property, 3 counts, improper payments of public funds, 2 counts, contravention of the Public Procurement Act, 2 counts, unauthorized commitment resulting in financial obligation for the government, 1 count. So those of you who are familiar with the case, there were purchases of cars, vehicle purchases, a lot of them, many, many vehicles. And the finding by the prosecution, which the court affirms, was that the places where she goes to buy the vehicles, they check, and if they sold the vehicle to her, one at say 100,000, like a month before, that same place was selling the vehicle for say 50,000. And you know, there are small cars, big cars, plenty of them. That's what brought the money so much to 90 million Ghana cedis. All right, so yes, Dr. Kennedy, what do you say about this? Legitimate asking, is she really in jail? And I was asking the question of, is it Dr. Bonfe, if handing her to the police and prisons, they were supposed to take her to the to the hotel.
She should be in jail. The conviction is clear, and you've read a lot of the charges. I think only lawyers would argue about whether when you spend a couple of years relaxing abroad, you have served some of your sentence. You know, it is common sense on the streets that if you haven't been in prison, you haven't served any of your sentence. So she should be in prison. I think the Americans will not extradite somebody whose health will be jeopardized by the extradition process.
Okay.
So it presupposes that if the Americans sent her down, they thought that she was in good enough health to travel. Of course, the Ghana Prison Service have healthcare facilities. There are prisoners who spend time in hospital when they are not well. So I take it for granted that they will take good care of her health. And I think that she should be allowed to go through the appellate process and all her rights should be respected. But I go back to my basic point. There is an increasing perception that we have tiers of justice, and that when your government is in power, the law is far more lenient to you than when your government is out of power. And that even if your government is out of power, if you are a powerful, connected person, the law seems to treat you differently. That sentiment underlines some of our dissatisfaction with our democratic process.
You said perception. You said perception, but that is perception informed by facts, evidence on the ground, right? So it may be factual rather than perception.
Well, both. I was just being diplomatic, but I say that our justice system must not only be fair, it must be seen to be fair, so that the powerful will be punished just like nobody's. I think there is too much of a perception that the powerful get unfair treatment, or they get sweetheart deals. And that was demonstrated by the Nolly prosecutions that we saw. That is part of why people are wondering whether she's in jail or not. So I think that for our democracy to be credible, the public must see that when powerful people do blatantly has done, stealing money, which has been proven by courts that they suffer consequences. When there are no consequences, then people start to believe that the powerful can get away with everything. And this is one case where we can demonstrate that indeed our laws work. I do not believe that, as one of the panelists stated, unfortunately, sometimes we are too quick to or eager to crucify. No, we are too slow. The law must be seen to be enforced, and this is one case where it must be enforced rigorously. If she is not well, the prison authorities must offer her health care. But yes, she should face the consequences of what she has done so that it serves as a deterrent to people in the future. I think that there has been too much ura about ura, and there needs to be action.
What do you mean by that? Too much oral about oral?
It means ura means we are talking, and ura is the initials of Operation Recover or Loot. So all what we are doing is that we are doing ura about ura.
In respect of that argumentation, actually, about when the sentence begins, a colleague lawyer says people should rather check subsection 1 before they move to the subsection 2. So I am projecting the law to you. Section 315 of the Criminal and Other Offences Procedure Act, which is Act 30. It says that warrants to be issued in respect of sentence of imprisonment. And the explanation one should get is very simple, that these warrants were issued by the judge. There was a warrant for her arrest. It is now that she has been handed over to the Ghanaian authorities that all of these things kick in. So signing of the warrants will now happen. So it is now beginning, not later. One says, where a person is sentenced to a term of imprisonment, the court which sentenced him shall issue a warrant of commitment, ordering that the sentence shall be carried out in any prison in Ghana, and the warrant shall be full authority to the police and prison officers to take, convey, and keep that person to all other persons for carrying into effect the sentence described in the warrant. Before it comes to 2, a sentence of imprisonment shall commence on and include the whole of the day on which it is pronounced. Thank you. So, what will you be surprised? And if you get surprised about what I'm going to ask you about, will that surprise suggest to you that she's being treated with levity because she's, NDC? Already we are being told about the analogy of the time she surrenders to the U.S. authorities, all the while when the NPP was in government and the extradition began, she, didn't show up, didn't surrender. And then suddenly she surrenders, and then around just when she will come, her accomplice, so to speak, the former deputy, is granted bail pending his determination of, his appeal before she comes in. So will you be surprised if she's granted bail pending her appeal? Will it be too much if she's so sick that the president feels that if all her appellate processes fail, she should enjoy a pardon?
Actually, will be surprised if she is granted bail, and it will fuel more my skepticism about the fairness of our judicial process. And secondly, if the president grants her a pardon, of course, he has a right to grant pardons, but it will still feed the public's perception that there are special deals for powerful people. I think that in this country, you are in more danger being a cassava or plantain thief than stealing millions from the state using a pen or connections. And I stand by that conviction. And if the president does that, it will only go to fuel that perception. Of course, you can do a pardon in which the person does restitution and brings back punitive damages, just like a plea deal. If something like that happened, I'll be more understanding of it. But for now, I think that she must serve her sentence. And if she is sick, she'll be provided health care while she's...
By the law, and what you just said, there are people who have also asked about that. By the law, plea deals are only open before judgment. Once there is judgment, it's out, it's not available anymore. So we cannot be talking about plea deals.
I use the term advisedly. You know, for example, before Ford pardoned Nixon, there was negotiation. And since Mr. Trump returned to office, there have been some pardons, and some of them have involved negotiations. So a pardon is just not just blanket. For example, a pardon can convert a death sentence into life. It can shorten a life sentence. It can obligate the person who has been pardoned to do restitution. So it is not a plea deal, but a pardon also involves negotiations sometimes, to the best of my knowledge.
Okay. But again, the 90 million, we are interested in that too. Again, when people are saying don't do A, B, C, just go and jail the people. You jail the people, you feed them again. When they are sick, you take care of them. And then what happens to the money? The 90 million. So should we be asking the state to account to us how much of that money has been recovered so far?
Yes, and I actually think that a custodial sentence is not incompatible with recovering the benefits of the loot.
That's right.
So I think that financial reparation can be part of the sentence.
Correct.
And whenever possible, it should be.
Right. All right. Thank you very much. And I need to state this to Ajay Bafo Ewa. So I'm reading verbatim. I was the attorney in charge of the case, and throughout his bail pending appeal, I handled it from the High Court to the Court of Appeal and to the Supreme Court, where he was finally granted bail. I opposed it strenuously for more than 1 year through the court. The court finally granted the bail because he argued that the Record of Appeal was not given to him when he asked for same for close to 2 years, even though I argued strenuously that he failed to follow up on it. He failed to follow up on it. Though on my own, I followed up at the registry several times, they were not giving. It was just on that basis that the Supreme Court granted the bail, because he did not get the record and he was served more than 2 years. He had served more than 2 years of his sentence of 5 years. Remember, he has 5 years. And there was the likelihood that he will not get the record before the end of his term of imprisonment.
Okay.
So, wait, the point is that he began a bail application. He said there was his bail application at the High Court. The Attorney General opposed it. His bail application at the Court of Appeal, the Attorney General opposed it. It then had to go to Court of Appeal, Supreme Court, where he eventually got the bail granted. And the only basis for which the bail was granted him was that the Record of Appeal, which should have been given to him as he's pursuing his appeal, had not been given to him for 2 years. That's not Attorney General's problem. That is the court's problem. We all, as lawyers, we fight that all the time. Then, because he has served 2 years of his 5 years already, if you don't grant him bail, there is the potential that he may serve the other 3 years, and then if his appeal succeeds, you would have already kept him 5 years in bail, in jail, and that would be unfair. So this is from the state attorney who did the case in respect of the former deputy director of MASLOC, Daniel Exim. I don't know if that's the name, how you pronounce it. Yeah.
Samson, this is my response. First and foremost, when you appeal against a matter, it is not the AG's duty to follow up the record of proceedings. You, the appellant, you follow up because it is your appeal.
No, the point of this attorney is that you were unfair to the AG's department. because you insinuated that they may have slept on the job and allowed the guy to slip through.
Samson, from where I sit as a politician, particularly the committees I sit on, the information that comes to us, that's why I was very careful not to say anything.
Because I kept asking you to show us what wrong the AG had done.
You know that is not my nature. You know me. But I'm very careful. And
he's having a tough time.
Yes, I'm saying that, Samson, disclosure at this point, would mean so much. But let me put it, Samson, you and I know that when you file an appeal, it is not the AG's duty to follow up on the record of proceedings. It is the appellant. And so that cannot be a basis to grant bail.
Okay.
That cannot be a basis.
So we have been, whilst we are having the discussion, we have been checking on the prison authorities too, to be sure about her status. So far, they are unable to tell us of her status, but they have assured us that they will give us information on her. That's
the conviction was in April 2024.
Correct.
Right? The bail was earlier this year. That cannot be 2 years.
Go ahead.
Samson, a lot has been said. Let us put...
That's 2 years.
No, April 2024.
It's proper perspective.
Right? So April 2024 to April 2025, 1 year. And then earlier this year, before April, that is not 2 years.
Samson.
Almost.
Go on.
It is never the case, and let's say this. We are lawyers, apart from the fact that we are also political animals. It is never the case it is never correct to say that in the trial of Sedina MASLOC, she fully participated. That is not true. Please allow me. You said a lot of, I beg you, this time, allow me flow.
You said you are lawyers.
Yes. So if you disagree, I disagree with you on a lot of fronts, but I allowed you. Please allow me. It is never true that she fully participated. Look, yes, we all know that trial in absentia, your lawyers can be there. That's what the law says. They can be there. But the lawyers cross-examine based on the facts that has been put before them. The lawyers do not state the case of the accused. That is factual. It is not for the lawyers. There's a criminal matter. It's not a civil matter. It is not for the lawyers to state your case before the court.
But the facts as he presented them are factual. That her lawyers cross-examined.
Yes.
Right?
Yes.
And that was a process that she participated in.
Absolutely.
I only said he should say partial.
And that's the point I'm making. That fully, the word fully is not true.
All right.
So please, Samson, a lot has been said. Please.
You are not going to start.
I beg you. No, I'm not starting. A lot has been said. It is also...
I choose not to call the witness.
No, please. No. But in this case, you are not sure.
The public haven't heard him. You speak to the public.
So it is not the case. Yes. So it is not the case that she would have chosen not, or she would have elected not to call a witness. She was not available. And I've said that is not the court's fault. Nobody is faulting the court. It is her fault because she should have communicated to the court. But it is also factual that she was not given the opportunity, or she did not avail herself to speak to the issues that were put before him. Her lawyers did not conduct her case.
She was given 16 months.
So she didn't come. That is not in doubt. You see, let us also put it this way, that with regards to the Abu Ghapele case, President Mahama, during his tenure, initiated the prosecution.
He didn't say he didn't.
No, but he said
he didn't complete.
No, but that is for the... No, you see, when we do this, we are not helping the people, because all the government would have to do, the state would have
to do. There's no point to respond to, because he said...
So let me finish.
It started with him.
Sam, let me end. You understand where I'm coming from?
So what are you contradicting?
Yeah, so what I'm saying is that at that moment, all the state has to do is to put the matter before the court. When the judiciary, or how they proceed with it till the end, is not within the remit of the executive.
He didn't say so.
No, but you see, it doesn't make any difference to say that the convict or the case didn't end during this person's era. Because the point I made was that he initiated this case against him.
Nobody has contested that.
Well, I know we are politicians. I know. So it must be made forcefully. No, you see, let us also put it this way. Look, he tried to put out a narrative, of course, which has been upheld by the court, and there is a conviction. as a state, you see, I was very careful in not going into the substance of the matter because there is conviction. But you see, when you read when you read Samson, this is very important. Look at the submissions that had been filed.
You mean the appeal?
Yes, the appeal.
No, he's reading the judgment. He's not interested in the appeal.
No,
the
but there's an appeal.
I agree.
You may not be interested, but I'm saying that at the moment, the woman herself is contesting those claims, and it's within her right. Do you understand the point I'm making? Yes, there is conviction. Nobody is saying there is no.
To the extent that the judgment has not been overturned, it remains the facts.
Absolutely.
Yeah.
Nobody is saying that. But it's also important. I mean, there is nothing wrong with putting out what the claim is now, her contention. There is no problem with that. But I would like to read.
Okay.
I didn't want to go.
Read her contention.
You see, you allowed him at the time.
No, I'm going on a break. Pay attention. That's what I mean.
So read page 50. I think 52.
I'm getting a lot.
All right. So we are waiting for Bernard to bring.
Bernard, you are getting a lot of time.
Bernard is reading.
No, I'm not getting a lot of time.
Says that transparency, trust, accountability, they are not mutually exclusive. A fugitive who is extradited cannot just be handed over to the police service and prison service without photographic evidence. Elsewhere, even suspects get their mugshots taken and released to the public. Why is convicted Sedina Atienu different? This will do nothing to quell the speculation and suspicion by some citizens, including myself, that she may be giving preferential treatment by this government because she is one of their own. Provide the public with photographic evidence that she is in custody and tell us exactly which prison she is being sent to. That is transparency and accountability. How often do we not hear whether a convict is being sent to Insawam prison or wherever? Why is this different? Let me tell you one thing. Let me tell you one thing. The lawyers on this table who have been practicing, who are in active practice, can tell you that some of the times when they are even there in the prison, they are enjoying. These political people, they are enjoying.
No, please. You see, when you look at page 50, that's paragraph.
It's coming.
She responds to the charge of the conviction on charges of conspiracy to steal and stealing. This is what they say, the lawyers say. Now, moving on to the conviction of the appellant for purportedly dishonestly appropriating 500,000. It's because of what had been raised, which is the property of MASLOC. We submit that the prosecution did not lead sufficient evidence to prove this allegation. We are therefore of the considered position that the trial court ought not to have in the first place ordered for the appellant to open her defense in respect. Then she cited that Akilu versus the Republic. But this is what he says. He said, now seeking to prove the claim of stealing against the appellant in respect of 500,000. The prosecution claims that a cash amount of 500,000 was returned to the appellant by the board chairman of Obatampa, which according to the prosecution investigation showed that the money was not paid to MASLOC. The prosecution also makes reference to purported letter from the appellant allegedly acknowledging receipt of the payment of 500,000. The appellant in a caution statement, which is found at pages 80 to 83 of volume 1 of the record of appeal, denied knowledge of the letter. The appellant, having denied uttering the alleged letter of acknowledgement, the burden was on the prosecution to establish that indeed the appellant uttered the letter. We submit that the trial judge was in error when she held that the burden was on the appellant to establish whether the signature on the letter of acknowledgement was hers or not, whether she received the said amount. It is important to emphasize that the Honorable Court in the case of Kesel Atufosin and order. Look, when you look at this, I didn't want to go into this because of obvious reasons. I do not want anybody to misconstrue my presentation in any way as defending her. But you see, this is what the lawyers are saying. Is it the case with your practice? And you are very good at it. A claim of a signature being put out there, and that is the main evidence with regards this, I mean,
to the 500.
To the 500. The woman in her caution statement says that it is not my signature. I don't know about it. That's what she stated to the police or Yoko. Now it comes to court. You know that the burden is on the state. She may even not say anything. She doesn't have to say anything to establish her innocence. Now, the lawyers are saying, I wasn't there, that the state did not lead any evidence to establish that the signature indeed was hers.
Okay, thank you.
You see,
sorry,
let's not go.
The point is
and the testimony. It is because you raised that one.
The testimony of Oba,
no, you see,
of Atampa.
No, it is her signature. It is her signature.
Was not evidence.
Whether it was actually her signature.
That evidence cannot be independent of the
as we have said earlier, please, what Bernard has read to you is what Sedina Atienu's lawyers are claiming. But what Ejay Bafo Ewa brought to you is what the judgment has said. Thank you very much.
No, he didn't.
But she was convicted on it. That's the bottom line.
That's what you should say. But he hasn't read the judgment.
He has read the judgment. He quoted the judgment. You can tell that he has read it.
No, but there is a point he
made. If you have read the judgment, you can tell that he has read it.
I have the judgment.
My guests have been James Kwabena Bonfe, Bernard Bediako Beidu, Kwabena Kennedy, Justice Samson, Nana Ejeba for Ewa. We'll be right back to answer that question, whether or not the NDC should be panicking as President Mahama's ratings slump. They drop like that. They drop. Somebody says, I won't say the advert. We'll be right back. Right. You're welcome back. This is Newsfile. It's your most authoritative news analysis program. As we always tell you here, controversy gives way to clarity. And Mahama's ratings have dropped. The NDC, should they be alarmed by the IEA survey? 9.1 drop. The survey was done in May 2026, and it showed John Mahama's approval ratings dropping from the 68% in December 2025 to 58.9%, a 9.1 fall. Disapproval stands at 28.4%, with 12.8% who are undecided. The approval was driven mainly by perceptions of economic management. That's 73.5%, while disapproval stemmed from cost of living concerns, 30.9%, electricity, 29.9%, and corruption, 19.1%. So is Mahama's political capital eroding beyond repair, or is this just a temporary dip in a volatile electoral climate? Should the NDC panic, or they should not? They should dismiss these as elite-driven statistics with little grassroots resonance. And this show is brought to you by Bank of Africa, strong as a group and close as a partner, MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, dial *165# on MTN to join My Way today. Syntex Tanks, it's strong, it's tough. Safari Valley Eco Park, bringing you closer to nature. Gold Board Jewelry, pure, precious, proudly Ghanaian. Melcom, your #1 shopping destination. Waylead, your trusted home builder. Bethel Dental, the smile starts here. St. Thomas Eye Hospital, providing excellence in healthcare. And Curl Charcoal Toothpaste, happy smile. Let's begin with Dr. Bonfe. You are the people who know the political, situation well. isn't this normal that immediately you win power, and the way they win so massively, they won so massively, the survey in 2025, was spot on. But as the years go on, it will drop. So this is natural. They shouldn't be panicking.
Well, Samson, thank you very much. I think that with your kind permission, I'll just lump this and Afari matter and leave you to finish. I have maintained on this platform before that an interrogation of the 2024 elections outcome would sober both winners and losers.
How?
And they should tell all of us within the political space that the electorate are as discerning as they ought to be, and they make choices, including choosing not to vote at some point as a way of voting. Now, if you look at it carefully and you juxtapose that to what we are confronted with now, the IEA survey, I am not surprised that approval ratings of the president will drop. I've not looked at the study, I haven't seen it. I will not be surprised. A lot has taken place within the period, and it will be surprising if the president will have his approval rating go high. In terms of the statistics, that is why I always say that the statistics don't always tell the story. Sometimes beyond the quantitative figures, you have to look at the qualitative dimensions of how people interpret or understand them. So what has been the cost of living and how people feel them? You have the indices. We have exchange rate doing well, the cedi doing very well against the major currencies, particularly the dollar, and yet the prices of items on the market have not come down. In response, what is happening? Why is that dichotomy? Then you look at electricity, you look at water, and salaries haven't done better in response to these things. So definitely, people are not going to be okay with that, especially when they understand that if your currency is doing well and your inflation is supposed to be doing well, then it means that in terms of their cost or expenses, they should be doing better. And the opposite is the case. So something is wrong somewhere. Then you look at some other factors that have taken place in terms of what people expect and the promises that were made towards the 2024 general elections. So I am not surprised. However, this is my point. We are 18 months into this administration. The president has always got the opportunity to bring some renewal, some new spirit into his administration by way of reshuffling.
And consider the lives of.
And the reshuffling is not necessarily the people who are moved about.
What will reshuffle do to Iran, and what will it do? Is the economy people are looking at and these things?
Yes, and the reshuffle will help in responses that you put out there. At the end of the day, it's about who you put in at which place. When people get too comfortable at certain places, and I don't see the government, or in terms of the presidency, the kind of whip that should be cracked. Not long ago, we saw what was happening among key cabinet ministers. So untoward. We should not even be hearing of those things. A phone call, simple phone call, could have solved some of the issues that we were hearing about in the media. So all I want to say is that the president has an opportunity to draw lessons from the IE research.
A president that experts say he's becoming a lame duck already. His party people are crisscrossing the country.
All those offer him an opportunity to rethink and reposition himself. He must let everybody in his administration understand that no one is indispensable and that he is in charge. That is part of the indiscipline we talk about. And I talk about the security aspect. Even though sometimes I'm careful because at the end of the day, national security, intelligence and all that, they have to pander to the political whim of the president, whether he will take the information they bring and act on it or not. So I want to leave that there and go straight to the Afari project. Samson, here is my take. One, we need to understand that governance and government is a continuum. If we had dealt with this matter, which is all part of the Eurojet project, 9 hospitals in all. In fact, my brother Justice would speak more on this authoritatively. There were supposed to be 9. 1 military hospital, 2 regional hospitals, and 6 district hospitals. Out of these 9, I think about 6 of them have been commissioned. All were commissioned by His Excellency Nana Addo Dankwa Akufo-Addo. How did these things start, and why are we with Afari? Afari originally, Samson, was to be sited at Sofo line.
Yeah, no, originally it was in the north.
No.
To start off with, no.
I spoke to the Deputy Minister for Health at the time, who at all times was the instrumental person that was a go-to person to President Kufuor, the Honorable Abraham Juma Odu, he was deputy to Correct Koshiga. The military hospital was to be sited at Sofo line. Then when the government changed, they moved it to Tamale.
Yes.
Then there was agitation in Parliament.
Yeah,
so they brought it to Accra to 37. And then there was agitation. Otumfuo, I understand, got involved, and it was taken back to Ashanti. When it was taken back to Ashanti, the land at Sofo line that it should have been sited at had been encroached. So through the effort of the Otumfuo, they got a place at Afari. Why did we have to do all these things? And at all these times, the contractor was mobilizing and moving. So it also brought about some variation in the contract sum and all that. As we speak now, my understanding is that a lot of the work that were expected to be done have been completed.
Very beautiful fact.
It was left with the sewage system, which was at 70% complete, and the amount needed to complete it is not that much. I don't know why, if we can do this thing, complete it, and it will reduce the burden on Akufo-Addo, we are not doing that. The regional hospital at Siwa is also said to be at 90% completion or so. So that we would not have had the situation where Dr. Pakwesi Bedu was asked to show reason why he should not be suspended, and eventually Otumfuo had to come in to plead with doctors not to go on strike in solidarity with their chief executive. Samson, as a country, nobody runs this government or embarks on projects from their pocket. Governments or leaders initiate policies and programs through their vision and their commitments. Yet, the funding is done by us.
That's right.
Even when we procure loans, it is the citizenry that will pay it. We need to get this right.
They make you feel like they are doing us a favor.
And so this idea that if we don't complete it, or when we complete it, it is this government that will take the credit and all that. Please,
so
our leaders,
call them out. Please, with respect.
Who is failing to complete it?
They are asking a simple question. That for 8 solid years.
Yeah.
Because this was commenced in 2014.
No, please.
No, you have done that other history. But the actual project that we are talking about now, in Afari, 2014.
Yes.
And so when they didn't finish, 2016, they left government. Then, the NPP took over. He sat there for 8 years, didn't finish the whole thing.
Yes.
And then John Mahama comes, and in less than 2 years, you are there shouting that it's not done. How sincere is that?
My narration was to tell you that I am not speaking along the same line of whoever went anywhere.
Right.
I've avoided that because we need to move beyond the pettiness of these arguments. Of course, the government is not innocent. What has been the attitude of the government? But I have decided to move above that fray because as a country, we are tired and sick and tired of this attitude by people who are privileged to be elected and entrusted with the power of the state.
Thank you, privileged.
It's a privilege, isn't it? And we pay you. And we are saying use our money to complete this work so that our health situation will be improved. And then we are playing jigsaw. Please, please. The president, and these are some of the things, Mr. President, that can help you, recover from the slump. So I want to conclude by saying that it was a good initiative under former President John Agyekum Kufuor. We have been able to do some aspects and completed about 6 of them. The 3 that are left, let us go ahead and finish hard. Let us go ahead and finish hard. Remember that the Ga East COVID, the one that saved a lot of COVID situation, was part of that arrangement.
Thank you very much.
It was supposed to be at Medina.
There's something at Ga East, but what we build...
these politicians sometimes they just want to change the venue to take the glory. What is all this about?
It's interesting.
James Kwabena Bonfe Jr., a CEO of Census and lecturer at UPSA. We'll be right back. You're welcome back. This Newsfile is your most authoritative news analysis platform, and here on Newsfile we put Ghana first. Dr. Kennedy, quickly, we don't really have time, so you decide how you go about this. If you want to prefer the Afari issue over the ratings dropping, that's up to you. But very quickly, what do you say about any of these issues?
Well, the issue is not the president's rating dropping. If you do that, you are being too narrow. I would commend to your viewers 2 other important pieces of information. In the 2024 Afrobarometer survey, 82% of Ghanaians thought were headed in the wrong direction. In addition to that, they asked a question: if you think politicians are misruling in their own personal interest, blah, 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 do you think the military should step in? 50.6% said yes. And in addition to that, I like to disclose that a professor of mine from Legon, which some people here will recognize, called me. He said, Atake, after we saw what reaction Ghanaians had to Traore, we need to sit up. We need to have the MPP be a viable opposition. So putting all these things together, our democracy is in crisis. It is not just John Mahama's administration. I think people think that our democracy is not delivering. And the earlier comments you and the panelists made about traveling to your station with garbage in the streets as a result of a 20-minute rainfall underlines that, together with our economic problems. On the Afari thing, the MPP government had 8 years to complete this, regardless of everything that happened, and they didn't do it. Shame on them. They should apologize before they say anything. But now that we are here, the Mahama administration should complete that. All this became necessary because of this CEO suspension and the directive by the president of not turning any patient away. We need to study this no-bed healthcare situations, because in places like Britain and United States, they even talk about ambulance time. We need to stop just issuing directives and do systematic study of things so that we can solve these problems and stop finger pointing.
Okay.
We need to complete the Afari Hospital, but the MPP should bow its head in shame. It had 8 years to complete it and it did nothing.
All right. Thank you, Dr. Kennedy, for joining us today for this program. As always, we are very grateful to you. Thank you. So, yes, Nana, why visit the place and don't give an announcement, and then you go, you face, a problem, and suddenly all hell must break loose? I don't know if you are starting from there or you are starting from whether or not it is misplaced to look at the drop in ratings.
I'm not sure whether they went there without notice to whoever is in charge.
It was without.
We need to differentiate an announcement from notice. An announcement would have been to the world. Notice would have been to the persons who are caretakers of the facility. I'm not sure of it, but I think we need to look at the Samson. Whatever the case may be, it highlights a persistent problem. And that highlight is what we should be discussing. If you look, being a member of parliament of Menchia South in the Ashanti region, I know the problem in Kumasi. Akufo-Addo Teaching Hospital is relied upon by not just people in the Ashanti region.
Right.
People from the Bono Ahafo, the Bono regions, Ahafo.
Far up to the north.
Far up to the north, and to even western north. And so we really have a situation on our hands. I've been visiting Akufo-Addo to see a lot of my constituents. In fact, somewhere last year, my mother was even admitted there. And it's an eyesore. Look, we need to be humans as leaders. And I need to emphasize this. If you go to Akufo-Addo very early in the morning, Samson, you will cry. And that was why I said that, look, our education is not solving problems, because we go to school to be worshipped, to be served, and not to serve. And that is why we are not thinking to find solutions around our problems. We should be able to find solutions. Sometimes, even in the absence of money, we should be able to find solutions.
And Dr. Bedu takes the right decision and he's getting suspended.
What stops us from even partially even operationalizing the facility, if possible? What stops us from partially operationalizing it? For instance, Doc, you know that there are situations which Akufo-Addo may be stretched. And so we can say that for this situation, let's move them to Afari, and that we are partially operationalizing Afari. You see, we need, if you go to Akufo-Addo in the morning, people waiting to go and see their relatives, sleeping outside, and they sleep there overnight. It's so sad. And so I think we should take the politics out of this. There's a real medical situation in Ashanti region.
We understand that it's overall is 60% complete, but that is with civil and architectural. Civil and architectural works are at 97% complete. But when you say it should be partially used, how can you use it partially when biomedical and mechanical installations are only at 5%?
So, Samson, you can do things.
Because those are the most important things.
You can do things in phases. Samson, you can do things in phases.
Only 5%.
Why do you allow the facility to fall apart or rot, right? When you can do things in phases. It's the same with, look, Samson, if you recall, the maternity ward at Akufo-Addo is stood there for over 40 years.
Yeah.
It stood there for over 40 years.
So Kambuasin brought attention to it.
Exactly.
And the first lady assisted.
Look, and these things are taxpayers' money. Taxpayers' money. And they are mostly loans which are paid with interest.
Right.
And so I think that we need to focus on it. If it cannot be completed in its entirety, we should consider, completing them in phases where possible. Let me look at President Mahama's.
Hold on with that.
Yeah.
Speak about that quickly.
So you see, Samson, I think as a people, we continue to do ourselves a lot of disservice. It is as if we don't even love our own selves. Look, the idea to build these hospitals, if you look at the time that the agreement was signed and parliamentary approval was given, to this, it is 18 years. Kids who were born at the time.
We had all of this pending, and we brought in Agenda 111 in addition.
You hold on.
We wouldn't finish this first.
You hold on. For 18 years, with all our resources and everything, we cannot complete hospitals. Kids who were born at the time are now adults. Probably some have even given birth, if unfortunately they became teenage mothers. It tells you that there is something basically wrong with us. You see, as it stands now, the facility itself, per the reports that we are being told by the Deputy Minister of Defense and then the House Committee, is that the facility has started deteriorating. Equipment, some have been damaged, some have been stolen, some have actually been auctioned at the port. Yeah. And I ask myself, property of the state, How can we allow these things to be auctioned at the port? And I'm sure most of them may have gone to cronies and what have you, because we never saw a lot of these things being published in the papers that hospital equipment are going to be auctioned.
But you are forced to preserve. You are forced to get the little you can rather than allow it to go waste.
No, they were kept at the port, demurrage and what have you. So it became an auctioned activity, not because we were selling to recoup the money. The facilities that have been installed in the Afari now, some are being damaged, some are being stolen, some are being destroyed. So you ask yourself, are we not going to follow the same trend that took the mother and child building in Akufo-Addo about 40 years?
Over 40 years.
It had to be knocked down. It's as if there's something wrong with us. And it is not only about Afari. Look, even here in Accra, there's a children's hospital at Weja. That facility is practically done. Equipment, everything are in there. But we still don't want to operationalize it because of what? Issues around procurement, issues around litigation, and what have you.
Okay.
Meanwhile, that building here, it's actually bigger than the children's hospital we have in Accra here.
All right.
And arguably, even bigger than probably.
Okay. Bernard, quickly, and let's go to the ranking ratings.
Samson, look, of course, it's a fact that actual construction started in 2014.
And by 2017, the architectural and, virtual the construction had gotten to about 90%. So, as has been said, it is more of the mechanical and the biomedical installations that is really the problem now. Look, and that is why we must see it as a test that the MPP under Nana Addo Dankwa Akufo-Addo in this regard really failed the people of Ghana and the people of Ashanti region and even beyond. Because a 500 bed, look at what we are discussing. Today we are discussing this because of what is happening in Konfanoche. For which reason somebody has to even be, asked to go on suspended and all that. If this was really a matter that was of priority to the government at the time for 8 years, we would not be discussing this matter. Let's say it as it is. They may have done things elsewhere, but in this regard, they failed. Now, you see, but it is obvious, and we must say this. Look, three very important, apart from this one, there are two very important, let me say, very important, let me put first and foremost the factory at, is it the sugar factory? What's the name of that? Commander. Because we are talking about losses that may have gone into, the construction of this, and because of course time, some of these equipments, because of obsolete and then all that. You abandon it for 8 years. You know what sugar, the amount of money we use in importing sugar.
You don't want to bring that subject here.
No, I will, because you see, whatever it was, and for the 8 years, it should have been resolved. He's talking about the children factory out there.
Because you yourself, your regime, you are unable to revive it.
No, 1.5 years. Yes, and I will give my conclusive remarks. But you see, beyond that, Sagleme, we are saying these things because because whatever I keep saying, you had 8 years. If somebody needed to be arrested and prosecuted, you had all the time. Nobody begrudged you. You took Alhaji Kolinzada and co. I don't know what has become of that case.
You don't know what has become.
No. What has become of that?
Your AG filed.
I'm saying that. 8 years. You had 8 years. If you didn't have anything against anybody, because somebody raised an issue, you only took somebody to court. The new AG comes and he says, "I don't have anything to prosecute." This issue of what's the meaning of nolly prosecute? Because indeed, during your 8 years, you couldn't do anything. It was just a political. So what we are saying is this: look, you failed Ghanaians in some respects. When we speak about abandoned,
so in the last 18 months, what are you doing?
Yes, what we are saying, and it's been said. Now the contractors are here, has left site, and he's claiming to, some amount,
78 million
and all that.
Yeah, 78 million.
We are praying the government, because you see, it is President Mahama's legacy. 8 years, somebody did nothing about it. You are back. It is only fair that you put this property or this
Omanibuama made it priority. It looks like after, unfortunately,
it will be done. Per what I'm hearing, it will be done shortly. And once it's done, it becomes part of the legacy of President Mahama.
Okay.
Beyond
so
that,
fact, I need to correct some facts. I need to correct some facts. The lot of the staff, they are warehoused, so they are there. And the other fact is also that Ken Ofori-Atta paid the contractor a lot of the money, right?
But that
was why the contractor continued up to this point. So it wasn't that it was abandoned. Look, it's coming from very reliable source.
Okay.
The contractor.
All right.
So Samson, let me finish.
Way forward.
Samson, what is left is for the government to pay the balance to the contractor, and the contractor will complete it.
All right.
This is coming from the contractor.
Bernard,
I'm saying that this is coming from sources
over
the construction company.
Are you panicking?
Well, Sam, no, not at all. Not at all. Because if it's even anything to go by, we still have majority. If we are to pay what we have before us. But let me find out something. Maybe because there is research and we need to get into it. They say that the rating dipped from 68% in 2025 to 58.9%. That's what they claim. Is it a fair one? Because you see, in 2025, you did a 1 year thing for President Mahama. After 2025, I would say that if you are calculating, you can help.
You should wait for another 1 year.
No, not really. But it's the 6 months from the December.
Yes.
Yes. So you don't say within 18 months, it's dipped from, I don't know whether you get the point I'm making.
Put the two.
No, but you see, that's unfair.
No, it's not unfair. See.
Let me explain to you.
See.
No, I'll come to that.
See, Samson, for me.
No, let me finish. So I'm saying that in December 2025, you had it at 68. Now, after the 2025, I thought that you will be doing a fresh 10 for 6 months. And the fresh 10 you are saying is 58.9. No problem. You see, what it is, you can understand. If we are being told that 19.1% of people had issues with corruption, what is the corruption? They are disappointed, if it is the case, with the slow pace of this aura and then other things. People want to see action.
And OSP being in hiatus, they would be very disappointed.
But nobody has done anything to him.
No, it is because the fight on corruption from that point is on freeze.
Why is it on freeze?
They can't prosecute.
No, but that matter, we've had that discussion because you see, go and take because the court is saying you need that warrant. Go and take it and prosecute. What we are saying is this. It is a fair one, and the government is looking at it.
Okay.
What we are saying, obviously, you should understand, you meet an economy in the nature of the one you had. People had expectations that from day one, they would want to see certain things. Obviously, a government of this nature having met the kind of mess, and you agree, we had, you need to take your time and then make sure certain fundamentals are still.
Yeah, but the work must be incremental.
No, but you see,
you peak and then you slump.
No, it's not. It's not. You see, Sam, it's not.
Okay.
People are desperate to see.
I need to move on. Yes, Nana. Yes, Nana.
So I've maintained that there's a difference between the virtual perception of a government and the actual perception, and that is what is playing out. Previously, your perception that you were doing very well and so on and so forth was playing out on social media. The actual perception is what is now coming.
Virtual and actual.
Virtual and actual. This is the actual perception. People are now beginning to see through the government, right? Now, you said that you came to meet so much mess. You didn't come to see the mess, any mess, as regards Nana Addo Akufo-Addo or Dr. Bawumia giving the man mines to his brother and then other mines.
You want that discussion?
Wait. Now, the people have seen that contrary to what you told them, contrary to what you came to Parliament to say, that you're going to pass a law to ensure that state assets being sold to government appointees and their cronies, right, saw some level of transparency and did not become the norm, that law hasn't been brought. And now, state assets are being sold to relatives of the government, particularly our mineral resources. Now, you promised the people of Ghana that single sourcing was going to be a thing of the past. In your inaugural State of the Nation's address, you came to Parliament, and then you made the same commitment. In your subsequent state, if it wasn't possible, why did you promise?
We didn't
in your
say
subsequent State of the Nation's address.
We never said that.
He moved.
No. We said it will not be the norm.
Let me finish. We don't have
It's a different thing from the thing of the past.
He said that.
You couldn't have said that because the law allows.
In the most recent State of the Nation's address, the president moved from it's going to be a thing of the past to it's going to be a rare happening.
What said it will be a thing.
Gradually, people are seeing through the goalpost shifting. Now, people have seen that in terms of real employment, you don't have anything for the youth of this country. The teeming youth.
24-hour.
The 24-hour economy, they have discovered this.
What's the brand again?
133.
133.
133 is a soccer.
We need to stabilize the economy. With this magic.
133 is a soccer formula.
They are building 24-hour markets across the country.
Can you
so
imagine?
it's working.
Samson, what do you call it? KJTR market. In the night, who says there's to sell?
Which you fail to do.
There should be demand before there is supply. People have seen through you, and the reality is settling down. Now they have realized that the only thing they have is the exchange rate. That is why they are spending so much money to hold it.
That started going up.
And that has also started going up. So Ghanaians have seen through it. The only thing President Mahama has now left, right, is his smiles. That's why he keeps smiling a lot. That is the only thing, because he wants to be remembered for being a nice person. And that is the only thing he has left. That is the only thing President Mahama has left. And that is why he has 58%. Because 58% of Ghanaians now see him to be a nice person because he smiles a lot. But the actual perception is that this government has nothing to offer Ghanaians.
Really?
Yeah.
That's it.
Samson, I think that the question as you put, NDC alarmed by this. I think for me,
he says they are not.
Not at all. They should not be alarmed, but rather they should be very concerned.
Yeah.
You see, the first year of every government is like a honeymoon period. Thankfully, a lot happened to our economic indicators.
Great.
Things looked good. But now the reality is on us. They are beginning to spend and what have you. So if you look at the research findings, issues relating to cost of living, corruption, and what have you, these are the basic things that start the negativity towards any government. We need to pay attention, as in the NDC government, they need to pay attention and make sure that they quickly go back on track.
The attention is on 2028.
Well, by the time we get there, if they don't fix things now, they may be looking at the other side. They should fix things now.
Well, from where people like Ata Kennedy sit, that's not possible. No, the MPP should just forget it for 2028.
It's not about the MPP. It's about the people of Ghana being happy or otherwise. The promises, the hope, the 3 jobs, what have you. If people don't see this being manifested in their lives,
right.
If people are struggling, if people are doing that, and they see problems around them, that is when they become disenchanted with you.
All right.
So they shouldn't think that it is all good.
Right.
For me, this is a wake-up call. They should take it in good faith. Look at what is happening.
And Bernard said, you are taking it in good faith, right?
For me, that is the
I have been reading the report. I know members of the government are also looking at it. I mean, it's a faith. Yeah, it's a research.
But before I end on this, on this hospitals and abandonment, I think going forward, we should be looking at the solutions. And I will urge the president, as a matter of urgency, he should put up a team to oversee all the abandoned hospitals and possibly get the Minister of Finance.
Call them out first. Call them out.
Please.
They failed.
Don't wait. Don't worry. We'll talk about it.
No, do that now.
It's been mentioned here. You also have a role to play. It's been 12 years. NDC.
Focus on the solution you are talking about now.
For me, a team should be put in place. They shouldn't leave it just to one ministry because there are illegal issues there. Bits of it, Afari is under the defense, some are under health. A team should be put in together. Make sure that all the abandoned hospitals, not just Afari, are put in shape. And I wish the president could direct the Minister of Finance to make some funds available in the medium budgets, purposely for those abandoned hospitals. Because as a people, we have invested so much in there. we are losing the benefits that we are supposed to get out of them. Look, the economic benefits that would have happened if all these facilities were in place, it's enormous, and we are all losing same. The money we've invested, we are not getting.
Thank you very much.
You should call them out because you were the general secretary.
Please listen to me.
But you failed to tell them.
Call them out for all this. You
can't do that.
Please. Give me the point.
You said we'll do that another time.
I'm doing it now. It wasn't abandoned. Let me make. Don't do this. Your people are listening. 8 years. Your people are listening. See, your consequences are listening. This side. Then you put $400 million into Agenda 111 when you had a strategic hospital like this.
All the politicians.
You did nothing.
But if we did nothing, how come we got into
NPP should all be
60%? Especially it was like the architecture in the
we've seen president.
The place is bush.
My guests have been Dr. Justice Jansen, Dr. Arthur Kennedy, Bernard Bediako Beidu, James Kwabna Bonfe. Thank you also very much. I'm Samson Lardy. Anyenini, my outfit as always is by Habil Scooter. You can call them 0200 84 1988. 0200 84 1988. Have a good afternoon.